Good morning, everybody. Welcome to TCF Live. My name is Dan Soul, and I will guide you on a 3-hour journey through Courtlandia on this glorious Monday morning. Start in Michigan, Magistrate Chisholm.
Mr. Mobley, if you would unmute yourself, please, and turn on your camera. Mr. Mobley, please unmute. There you go.
Yeah.
And your camera too, please.
And the camera, okay. Got it, yeah.
This is 26RO04702. You were cited on July 8th for driving on expired plates in the area of 13th Field. When did you get the new plates or tabs?
I got that renewed on the 8th of July.
Okay. What document are you reading from, sir?
This is a receipt from Secretary of State.
Okay, can you put that in front of the camera for a second? And then if you speak, the camera will focus on you and we can read it.
You want me to speak, you said?
Yes, please.
Okay.
But if you would say something when the camera's in front, or when you put the document in front of the camera.
Okay.
You just need to make a sound, sir. So, but you need to put please put the document in front of the camera so we can see it.
Do I have it right, Your Honor?
No, I don't see the document at all, sir.
Where am I? I'm not sure where am I supposed to aim. Can you see it now?
No.
No. Okay, over there.
We see your face.
You're right. So I'm kind of lost. I don't know what to do.
If you put the document in front of your face and then say something, I think we'd read it.
How about that?
How about that? Okay. Is there anything you want to add to this, officer?
Yes, Judge. I'd be willing to dismiss this ticket.
And Mr. Mobley, the plates were expired when you were stopped, correct?
That was correct.
Okay. The officer has moved to dismiss the ticket. The ticket is dismissed. You are good to go, sir. Thank you.
Thank you.
This is citation 26RO04433. Mr. Latham, you were cited on June 24th, making a prohibited turn Webster and Warwick Streets. You can admit or deny responsibility, or you can admit with an explanation. How do you wish to proceed here, sir?
I would like to admit responsibility with explanation, but it's not valid to get me out of a ticket.
What is your explanation, please?
Well, I had just moved to Berkeley about less than a week ago, and I know the signage is very visible, but I wasn't wearing my glasses that day, and I got pulled over. And it said you could not make a left turn down the side street from 4 to 6. And I apologize to the court and to the city of Royal Oak for doing that. It was something I haven't done since. I know that.
Is there anything you want to add to this, officer?
No, Judge.
The fine on this Mr. Latham is $130.
Okay.
The points. As I look at your record, it appears that you're eligible for the Secretary of State's program to take an online traffic safety class before the points go on to stop the points from going on. And it would be a good idea if you made sure that your driver's license address is changed, because the Secretary of State is going to send the letter to you at the address that they have for you.
Okay.
So-
Could I say one thing about that, Your Honor?
About the class?
Yes. Are you only allowed to do that one time?
Yes.
Yeah, because I actually have done that a couple months ago.
Oh,
I got a citation in Detroit for going like rolling through a stop sign late at night. And
oh yeah. It's a once in a lifetime.
yeah, so I was wondering maybe if you could like do something similar with the ticket, like maybe just make it a non-moving violation. And
That's 2 tickets within a couple months.
yes, and prior
That's
to that,
unusual.
I've
Yeah, the
went-
average driver goes 7 years, 9 months between tickets,
yeah, I went like decades.
right? Then you get 2,
Yeah.
right? Well, the fine is $130, and you can pay that online or by mail, or you could pay it at the courthouse counter if you want to come in and pay it there, sir.
Yeah, I could pay it today, actually.
Well, have a good day.
All right. Thank you.
Thank you.
Good morning once again, everybody. It is TCF Live on a Monday. Barbara, thank you for gifting 5 memberships. I very much appreciate that. I hope everybody's Monday is as good as a Monday can possibly be. We'll keep an eye on the magistrate. Let's stay in Michigan, but let's go say good morning to Judge McNally.
26B150399. All right, your name?
My name is Stacy.
All right, so you're going to plead the impeding traffic. You got to be careful though, okay?
Yes.
To that charge, responsible or not responsible?
Good.
All right, I'll accept the plea. 195 is your total. I'll dismiss the original charge. You're upset.
Then I can go meet
Yeah.
31st.
The 31st or the 24th? Okay, August 30th. All right, you're all set. Good luck. Thanks. Cassandra Shaw. 26 B151208. Your name?
Cassandra Shaw.
All right, so you're going to plead the impeding traffic, right?
Yes.
Responsible or not responsible to that?
Responsible.
Okay, I'm going to accept your plea. You have an entry or 2 on here. 170 is your total. You can go down to the cashier and make your payment. I'm dismissing the speeding. Good luck.
Thank you.
Thank you. Amy Lucas. 26W84369. Could I have David Redmond seated at the table here, please? My right, your left. Your name, ma'am? All right, so you're going to plead the impeding, right? Responsible or not responsible to that? I'll accept the plea, dismiss the speeding. 150 is your total. You're all set. Cashier under the hall to your right. Good luck. David Redmond, I have a seat there. You're free to, sir. 26W8435584. Your name?
David Redmond?
Okay, so you're going to plead the impeding, right?
Yes,
Responsible or not responsible to that?
responsible.
It looks like he didn't show up the first time. Right, I see. What was the bond amount that he posted? Can you tell me, Amy?
Let's see,
Close to bond?
165.
Yeah, okay. All right, I'm gonna accept your plea to impeding. 165 is your total. If that bond's in his name, we can just tell him to go, right? Let me see. Yes, it is. You're free to go. Thanks. Have a good day.
You too.
Matthew Curtis, 260-843-599. Come on up to the podium. Donna Nielsen, have a seat at the table. Jay Staup, have a seat at the table. Yes, that table over there, my right, your left. My right, your left. Over there, me. There you go. Your name? All right. You're gonna plead impeding, right? Responsible or not responsible to that? All right, I'll accept the plea. 170 is your total. Original charge is dismissed. You're all set. Cash surrendered all. You're right. Thank you. Donna Nielsen, 260-843-749. Come on up to the podium and tell me your name, please.
Devin Nielsen,
All
sir.
right, so you're gonna plead impeding traffic, right?
Yes, sir.
Responsible or not responsible to that?
Responsible.
I'll accept the plea, dismiss the speed. 150 is your total, okay?
Thank you. I'll pay that today.
You look like you're nervous. You're not nervous, are you? Don't be. Have a good day. Good.
Barbara, $10 super chat. Thank you so much. She says, let's make this a good Monday, even though there are 25 reasons to go, thanks, Dan, for all you do for us. Dan the man. Thank you, Barbara. And Barbara is referencing the pre-show. So if you're a channel member and you did not see today's pre-show, you should go watch it, because I did a list of 25 issues with Mondays.
You're into the hall to your right, and I'm dismissing the original charge. Good luck.
Thanks, sir.
Michael Rose.
Yes, Your Honor.
Well, Mr. Rose. How are you? 260-648-944. You're all dressed up for me and everything, aren't you?
Yes, I am, Your Honor. How are you?
Good, how are you? Your name?
Michael Rose.
All right, so you're gonna plead to impeding, right?
Yes, sir.
Responsible or not responsible?
Response.
All right, I'm gonna accept the plea. 150 is your total. You're all set. Nice to see you. Have a great day.
You as well.
Take care.
Thank you.
Caleb Preeman, 260-649-042. And could I have Autumn Smith seated at the table, my right, your left, please? Good morning, Mr. Preeman. Your name?
Hello,
All right, so you're gonna plead to impeding, right? Responsible or not responsible to that? You're all set. 150 is your total. Cash your end of the, right down the end of the hall. Go right out that door all the way down to the right, okay? Good luck. Autumn Smith, 260-648-968. And could I have Mr. Trent seated, or McKenna Trent seated? Excuse me. Excuse me. All right. Your name, ma'am? All right, you're gonna plead to impeding traffic, right?
Yes.
You weren't texting or using your handheld device, right?
It was in the film, but.
Can't do that, okay? For the charge of impeding traffic, responsible or not responsible? All right, please accept it. 170. You're all set. Thank you. Sure. August 24th, okay? Wow. I don't know what happened to the register on this one. I'm just gonna write on the STIP form, fines cost 170, paid by August 24th on that one, Amy. I don't know what happened to the register. I don't see it. Okay, McKenna Trent, 260-648-913. Your name? All right, you're gonna plead to impeding traffic, right? Responsible or not responsible to that? Okay, please accepted. Please accepted, fines cost of $160, okay?
Thank you.
Yes, you're into the hall to your right. Good luck. Dana El Sahim, 26F 246462. Morning. Your name?
Devin.
All right, let me see here. You want an informal hearing?
Yeah,
Did you have insurance?
yeah. I don't have it right here.
Was it in effect on that day?
Yeah. So, I got pulled over and then I was looking for insurance. He said that I was gonna hang out with the client till like they find it. And then when I told him back and he came with that ticket. So, and then he was like, I also.
So, let me see your insurance. Hand that up if you would. All right, so you did. Says you handed a copy of the insurance that expired in 2025.
No, I'm fine with it.
That's what he wrote on his notes. Reported, handed officer a copy of insurance that expired in 2025.
He didn't even, I didn't even get him, any insurance.
Listen, if you want to have an informal hearing, that's fine. I don't have a problem. You have to provide them with proof of insurance, though, and you didn't do that. So if you want me to set it for an informal hearing, I will. I don't know how you can win that, but if you want to plead responsible, I'll cut the fines down for you.
No, just do that, yeah.
Okay. You understand what I'm saying, though, right? All right, I'm going to hand you back your information here. We'll set it for an informal. Why didn't you respond to this? Oh, I see. I'm gonna motion hearing and informal hearing will be set at the same time, Amy. So I'm not setting aside the default judgment. If you want to give me a informal hearing date, I'll deal with it then.
We can do August 31st.
At 8:30?
Sure, yes.
At 8:30, okay? You can go down the hall and they'll give you a notice, all right? Good luck. Bring that insurance back with you, okay? Moss, Robert Felton Moss, 26F 246607. All right, your name? So you're gonna plead to impeding, right?
Yes, sir.
Responsible or not responsible to that?
Responsible.
Please accept at 160 cashier end of the hall to your right, and you're all set.
All right, thank you.
Good luck. Stephanie Tierra McGee, Charleston, 26 151079. Okay. Good morning. Your name?
Alliance, definitely here in the.
Okay, so you're gonna plead to impeding traffic, correct?
Yeah.
To that charge, responsible or not responsible?
Right.
Plea is accepted. 150 is your total. Cashier end of the hall to your right.
Can I set up a payment?
How much do you have today? When can you pay this?
Couple of weeks, I just started a job.
August 31? That's 2 weeks.
If that's what I have to pay if I haven't tried.
Just said you could pay in a couple of weeks. If you need more time, just tell me.
Yeah, more time. I just started a job.
I'll give you September 7th. Is that good, or do you need more time?
I'm not sure. I get paid.
I'll give you September 14th.
Okay.
If you don't have the money, then you call the court and go on Zoom, or you can walk in here before the due date and I'll give you an extension, okay? Good luck. Nasser. Akram Ali Qasim Nasser, 26B 151341. Your name?
Akram Nelson.
All right, you're gonna plead to impeding, right? Responsible or not responsible to them?
5.
Okay, I'll accept your plea, dismiss the original charge, 170 is your total, you're all set. Cashier end of the hall to your right, Brandon McCurdy, 26W843-738. And could I have Felicia Donald and Devin Hayden seated at the table, my right, your left? Your name, sir?
I am, named Brandon Perry.
Good, how about you? You doing all right? Okay, you're gonna plead to, impeding traffic, right? To that charge, responsible or not responsible? All right, I'll accept your plea. 160 is your total. Cashier end of the hall to your right.
Can I have to like August 28th today?
I'll give you till August 31, okay?
Oh, that's fine.
If you don't have the money, then call the court. We'll go on Zoom or come in and talk to me on it before that due date. I'll be glad to give you an extension, all right? Good luck. Thank you. Donald Talisha. I'm sorry, Talisha Donald. Sorry about that. 260-648-928. How are you? Your name, ma'am?
Probation.
Good morning. You're gonna plead to, impeding traffic, right?
Right.
Responsible or not responsible to that? Good morning. I'll accept the plea. 150 is your total. Cashier end of the hall to your right. Good luck. Devin Hayden, 260-648-922. Your name?
Devin Hayden.
All right, you gotta be careful. You got 3 prior entries. You're gonna plead to impeding, right?
Yes, sir.
Responsible or not responsible to that?
Responsible.
All right, I'm gonna accept your plea. 175, cashier end of the hall to your right.
Thanks.
Good luck. Thank you. People against Mark Green, 260-648-562. How you doing, Mr. Green?
Good, how are you?
Your name?
Mark Green?
You're going to plead to impeding traffic, true?
Yes.
Responsible or not responsible to? All right, I'll accept your plea. Set aside default judgment set aside. 165 is your total, okay?
Okay.
Yeah, give me 1 second. I just want to check one thing. I want to make sure that bond is in your name. I'm sure it is, but let me just double check it. Yes, it is. You're all set.
Thank you.
Have a good day.
You too.
Christopher Johnson, 26W843-750. Your name?
Christopher LaCaria, St. Johnson.
All right, you're gonna plead to impeding, right?
That's correct.
Responsible or not responsible? So I'll accept the plea, dismiss the original charge, 150, you're all set.
Can I get an extension?
How long?
After the first, please.
I'm sorry,
After the first,
the first good or you need more? I'll make it September 7th.
September 7th is great. So
If you don't have the money, call the court. We'll go on Zoom. I'll give you an extension, okay?
Thank you, sir.
Good luck. Bring in Michael Lee Edwards if you would, please, Amy. People against Michael Lee Edwards, 26F246543.
Bring them in from where, Judge?
It says payment plan balance 215 on Zoom, somebody wrote down. Is Michael Edwards in the courtroom by chance? Yeah, that's what it says. Somebody wrote down on a sticky note.
Okay, I'll figure it out. I don't see him in the waiting room.
Okay. Well, I'll just put it aside until you find him.
Hey, Heather. Oops, sorry.
Okay. Charlene McClendon, 267-843-775. Your name, ma'am?
Charlie.
All right, you're gonna plead to impeding, right? Responsible or not responsible to the, okay, I'm gonna accept your plea. 60 is your total. Cashier end of the hall to your right.
Make it extension.
How long?
To after the first.
September 7th, I'll make it, okay?
Okay.
Have a great day.
Well.
Lindsay Mitchell, 26B151266.
I need more time, can I call?
Yes, you have to talk to me though on Zoom. Where do you live at?
What is that, Wesley?
Okay, yeah, you could call and tell them you need to go on Zoom with the judge and ask for extension.
Thank you.
Okay, thank you. Lindsay Michelle Mitchell, 26B151266. Good morning, your name?
Lindsay Mitchell.
All right, so you're gonna plead to impeding traffic, right? All right, let me see something here. Okay, to that. Ooh, you gotta slow down, you little young lady. Huh? All right, to that charge of impeding traffic, responsible or not responsible?
Responsible.
175 is your total. Slow, cashier into the hole to your right, cruise control. Okay, good luck. All right, people against. Trey Jordan Peterson, 26W843591. You're another one. Your name?
Trey Peterson.
Got to slow down, sir. If you get another one of these, you're not going to get impeding, okay? For me, anyway, to the charge impeding, responsible or not responsible? Please accept it's the original charge is dismissed 175, cashier into the hall, you're right. Good luck.
Is there like a payment plan for that?
How much can you pay today?
I could pay the whole thing by the end of the week though.
Okay, I'll give you till August 24th. Okay?
Is there like?
Yeah, 33court.com. They'll give you instructions down the hall if you go and talk to them, okay? Right down the end of the hall. Have a good day.
Yeah.
All right, people against. Scott Michael Bearden, 260-710-492.
Good morning, Judge and staff, and welcome back, Judge.
Thank you. Your appearance?
Don, I'm not saying anything on behalf of Scott Beard, moving my left. Please identify yourself, sir. Scott Beard.
All right, so we have a charge here of failure to refrain from consuming alcohol, testing positive, on a chemical test on July 14, 26. Just for the record, this was adjourned because the defendant had an issue that prohibited him from coming last time. So how was he going to proceed on this?
Judge, he wishes to plead not guilty at this time. I asked him many times, I said, look, would you have a little bit of relapse? He strongly denied it. It appears they spent roughly about two weeks in the hospital since that period of time. We got evidence of that, Judge, and he's frankly in very bad shape, and it appears that in addition to the spinal tap, he'll be having hip surgery in the near future.
Do you have a stapler down there? I'm out of staples, I think.
No, it's Bill.
Oh, no. Jeez. Maybe it's just a stapler. The person. There we go. All right. We'll get Ms. Wilds in here. If you want to have a seat a second, I'll come right back.
Thank you. Yes.
That's on Bearden. People against Anaya, Jessica Lynn Anaya, 25R514118A and 25R254240.
Once again, good morning, Judge and staff. John Roxanne, on behalf of Jessica Nye. Please identify yourself. That's Bill Murphy.
All right, so we adjourn this. We set a sentencing date for today. What happened is she was in front of me previously on this on June the 22nd. I set it for July 20th and then adjourned it until today. She pled guilty to failure to provide proof of completing 20 hours of community service. That's on the 118A charge. And then on the other one, the 25420, I on July 20 said adjourn 3 more weeks, adjourn August 17th at 8:45, and I highlighted or jail if not completed. So that's where I am with it.
Judge, I'm happy to report that she's made significant progress, and hopefully it satisfies your threshold.
I'm gonna need let me get Madeline in here.
Sure.
Can you call her? So just for the record, on the other file, she pled guilty to failure to attend her scheduled probation visit on May the 11th. And, failure to pay fines and costs is ordered. No, failure to attend scheduled probation visit on May 11 was count 1. Failure to pay fines and costs was count 2. Failure to clear all warrants by May 1 was count 3. So she pled guilty to all those, and I told her she better take care of all of those. Has she paid all of her fines and costs?
I do not believe you, have you or not? She hasn't, Judge, beginning.
Has she cleared all of her warrants?
Yes, she has, Judge.
Yeah, I'm gonna need Madeline in here on
In
that.
addition, Judge, I just wanted to indicate for the record, she did pay $138 for the classes, which were mandatory under probation for impulse control. She has that scheduled on the 12th of September at 9 o'clock. And once that's completed, I think she'll be in a much better position to pay the fine. Again, her income is quite limited, and she's been doing her darnest to get this done. For the record, also, Judge, I want to indicate that she had about 20 and a half community hours of service.
She provided proof of that.
She does have proof of it. In addition, she did an extra 5.5 hours with a backpack giveaway at the Salvation Army in Buck.
Let me do this. I don't know what the probation officer is, so I'm gonna pass this case for now.
Certainly, Judge.
And we'll go on to another one. Scott Michael Bearden. 260-710-492. Ms. Wild, your name?
That's with Probation.
Mr. Bearden, your name?
Stop.
And Mr. Graziani?
John Graziani, on behalf of the state.
So I called the case, and Mr. Graziani says the defendant wishes to proceed with the hearing. And that's still correct, right?
That's correct, Judge.
All right, so for purposes of arraignment, I'm gonna enter a not guilty plea form. Are you ready to proceed? Raise your right hand. You solemnly swear affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole true self you got. Okay, go ahead.
Yes, Your Honor. On July 14th, 2026, I received notice from DNA that Mr. Bearden was positive on ETG, that while he was there, he had refused to sign the admit form or send it to the lab. In my communication with Mr. Bearden, following, he did email me and indicate that he was positive, that he did not have the $25 to send the sample to the lab. I did inform him that he would have to return, that if he was refusing, he'd have to return between 5 p.m. and 7 p.m. that day. This would actually be on the 15th, Your Honor. And that if he's indicating, hey, I didn't drink, he would actually receive his $25 back. If the confirmations are returned negative, defendants do receive the money back, Your Honor. He responded that he didn't have the money and that he wanted to speak with the judge about it. Emailed me again indicating that he claimed it was NyQuil.
Oh boy.
Went on from there kind of a little bit. Then when I met with him for his probation visit, I tried to speak with him about it. And what he indicated to me at that time was that he just wants to go to jail. It would be easier and that he would let you know that when you had his court date. So that's kind of where we left it, our conversation in regards to that test at this point, because the test was July 14th. That urine sample would be disposed of, Your Honor. It is only good for 30 days.
Right. You have a screening report with him?
I do.
What does it indicate? Does it indicate where he was working?
I believe he's on disability. I'm gonna double check the screening, but I believe even at the time of the screening, reports being on disability for the last 4 years, he received $741 in SSI and $321 a month on bridge card benefits, Your Honor. That's what's in the screening.
Okay. Do you have any questions of her?
Judge, all I'm going to indicate, and Mr. Bearden will confirm with me, is the fact that thinking clearly, prior to that incident, one, he needed a spinal tap. He was, again, thinking clearly. Number two, he didn't even have the $25 to pay for this. He's a part of the other half that's lucky to have anything at all, Judge. Like I said, he probably doesn't even have $20 in his pocket right now.
That's when you say it's for the next screening, which has not been warned since I've been out.
Also, he indicated to me that he was not thinking clearly at that time. There's evidence that he did have a spinal tap. He's going to be in a position where he has to have hip replacement surgery. In addition to that, then they have to do something to your spine. Tell me what happened.
I had blood.
Let's just talk about, let's just talk, first of all,
This does relate to that incident.
I know, but is he going to testify or is he going to remain silent? We're
He's
still,
testifying, he's all just, we've got nothing.
raise your right hand. Solemnly swear affirm under penalties of perjury that the testimony you give in these proceedings will be the whole true self you got.
Yes.
All right, go ahead.
Explaining what happened.
I've been in the hospital a lot lately. And
How much time?
At least,
Okay, when?
first, this is the second time where I had a blood patch, which is, I would have no problem. Next minute here, Hunter. I would have no problem giving the court of my chart, which.
Hang on a second. I just want to know when you were in the hospital. What day? You weren't in there on July 14th, right?
I have no idea.
You didn't go in there before July 14th, right?
I was in there before July.
For what days?
Let's see. I would have to look at my chart. I was.
Did you drink alcohol?
Absolutely not. I was in the hospital in Monroe County. I had been out for 1 day and I was on bed rest. And my wife is not gonna go and get it because I'm not allowed to drive unless it's absolutely necessary. And there's no alcohol in the house. They did not find narcos in the system, which is prescribed, and I told them that. They asked me when I went in there, do you have any narcotics in your system? I said, yes. I have a narcotic in my system, which is normal. 10-3-25. They do not find the norco, but they're gonna find alcohol. And I said, that's impossible. And they said, well, if you give the $25, I was like, I don't have $25. Like in my pocket right now, exactly $26, waiting on the orange test. So, Your Honor, I don't know how they found alcohol, but not my normal.
That's his color, Your Honor.
What's
Orange
that?
is his color.
He's referring to the date that he has to.
Oh, yeah, orange is.
When it says,
I call in every day, and whenever it's orange, I only you gave me once a month ago. So since I've been in the hospital, I've been calling. I only have 26. That time they told me to give them $25. I don't have it. Had it went in.
Does your wife work?
No,
she's on disability.
she's on disability. She's worse than me.
They're living on the edge, Judge, and they're lucky to even have this apartment.
Tell me.
I don't know what else I can say further. Again, Your Honor, when he emailed, as far as the Norcos are concerned, it's under cutoff. That's why. These are things Mr. Beard's not aware of. Again, try to have a conversation with him. I ended it after kind of the bad attitude and the bad comment in regards to he'll just go to jail. I ended our conversation. And again, you know, what he's claiming it was NyQuil. And
Did you tell her you took NyQuil?
That could be the only thing I'm thinking of.
Did you take NyQuil?
I take it once or twice, but once I got found guilty, or not found guilty, but came back positive, I threw that bottle away. I'm like, because I want no.
NyQuil's not going to cause you to test positive.
There we go.
I know that's a nice thing that people want to throw around, and
That's good.
unless they have 7 bottles of it.
Judge, I just want to indicate that Mr. Bearden wasn't rational. He was having these severe headaches. If necessary, his wife was in the courtroom, can indicate that fact, and as a result of it, he wasn't acting properly.
I'd like to apologize. I was acting like a jerk on that. That's
Well, why?
the headache that I had. I was
Headache?
just frustrated.
Okay, we all get frustrated. I get frustrated because I get people lying in front of me all the time. Anything else?
I don't have anything further, Your Honor. You know, if it was NyQuil, if it was anything other, it needed to go to the lab. And I'm at a loss again, after 30 days, it isn't anything where even Mr. Bearden had the $25 to send it now. It's not, it's an impossible.
No, I know.
Yeah.
Any argument?
Judge, I'm just going to indicate, I'm asking for continuation of probation, no jail time. I asked Mr. Beard, because I know you're aware of all these BS movements, so to speak, but, again, he was adamant, quite adamant, but he must spend a good deal of time in the hospital. And in fact, he has an appointment today at 1 o'clock to, determine when he'll get scheduled for his hip replacement surgery. There have been, like I said, significant spinal taps, but if it's necessary.
I'm not sure I can justify his conduct based on any of that, though. I'm gonna find him guilty as charged of consuming alcohol.
Judge,
I think he's just making this worse, trying to tell us it's NyQuil, saying he wants to go to jail, telling us the headache caused him to
Judge, headaches.
act differently. I mean, everybody has headaches.
Judge,
I mean,
these are more than severe migraines. This is a headache for a person will pass out. And it causes human beings to act irrationally. In fact, Mr. Durden has indicated that he did pass out.
you don't really want to go to jail, do you?
No,
Well, why don't you tell her that?
because I was a jerk. And I'm sorry. I know the headache is not an excuse. It's frustrating when I seen the time frame that I had to have community service done, which I knew was impossible.
Judge, for the record, that will also be another issue.
He doesn't have his community service done?
No,
He's also not involved in substance abuse treatment and lacks attendance to his 12-step meeting.
Why?
I haven't been in and out of the hospital.
Listen,
I
how many days, let me ask you a question. This is August the 17th. I sentenced you June the 2nd. That is 28, 59, 69, 76 days ago. Okay? How many of those days have you been in the hospital?
Not that many.
How many?
I've been in a hospital probably 21 out of that days.
Why didn't you go? Why didn't you go to AA during that time? Why didn't you get into treatment at that time? Why didn't you do some community service at that time? You're pushing me, and it's not going to end well for you.
I will complete it.
Well, I mean, you want to be belligerent toward the system, that's okay. I see that happen. Some people hate the government, hate this, whatever, I get it.
I don't feel he's being
Well,
belligerent.
I mean, I'm gonna state that again. I think he's just adamant that nobody's gonna tell him what to do. That's what I think. He can take it however he wants. He's getting smart with the probation officer. He's telling us he was on NyQuil. He's saying he can't do this. Wants to go to jail. Have you seen proof of any of his medical?
I have not, Your Honor.
Well, we'll want to see that.
Can I present it to Ms. Watts first?
Sure.
That's the last.
So you can make this as easy on yourself or as hard on yourself as you want, Mr. Bearden.
Really easy.
Well, so far it hasn't sounded like that to me.
I understand, sir. Yeah, I do apologize.
Give you 8 hours of community service. Sounds like you're having financial problems. I won't assess costs.
Thank you,
You're
Judge.
gonna do all 8 hours of community service and the other 32 no later than September the 14th.
Your Honor, I have to have it, I go today to work it out.
You come talk to me. I don't want to speculate. I'm not gonna engage in hypotheticals. You looked like you walked up here fine to me. I'm not. Well, maybe you're going to have surgery. I get it, but let's not talk about hypotheticals here. You have not been doing what you're supposed to do. And I would make sure I started doing it today. You understand what I'm telling you? Otherwise, we're going to have a big problem, you and me. Okay?
I have to have 40 hours done by September 14th.
That's what I just said. I meant it. I said it, and I'll say it again. 40 hours by September the 14th. And you better start going to AA, as I told you, and you better get into substance abuse treatment, like I told you. I'm not impressed with how little you've done so far. You got it?
Sir.
Okay, good. Thank you.
Thank you, Your Honor.
Put a 1 in the chat if you think we'll see him again soon. Just saying. Alrighty, once again, everybody, good morning. It is TCF Live on a Monday. It is great to have you all here with me. We'll keep an eye on Judge McNally, but let's go to Florida and enjoy the sultry sounds of Wade Mercer.
Mitchell. He's an assistant state attorney, and we have at least one interpreter case. Mr. Ricardo, good morning, sir.
Good morning, Your Honor.
I believe we have Oliver Villagran first.
You gonna do them both at the same time, Judge, or?
Sure, we can try that. With the interpreter, we can try it. The second person is Henry Teul. Mr. Ricardo, if you don't mind introducing yourself to both of them, make sure they can see and hear you.
Muy buenos días para ambos. Mi nombre es Jordani Ricardo. Soy intérprete para que se puedan comunicar con el juez. ¿Ustedes me ven y me escuchan? They can hear me and see me, Your Honor.
Great. Gentlemen, you have the exact same charges this morning. That's why I'm seeing you at the same time.
Señores, tienen exactamente el mismo cargo esta mañana, por eso los estoy atendiendo a los dos a la misma vez.
Each of you are accused of 2 counts of taking game fish by illegal method.
A ambos se les acusa de agarrar peces de pesca con un método ilegal.
And each of you have a hold from the United States Immigration Service.
Y cada uno de ustedes tiene una orden de retención de parte del Servicio de Inmigración.
I have read the complaint and there is probable cause in both cases.
He leído la denuncia y hay causa probable en ambos cargos.
And I'm appointing the public defender's office to represent both of you.
Y le estoy asignando al abogado de oficio para que los represente a ambos.
Please listen to Mr. McDaniel and we'll see if you have any questions in just a minute.
Por favor, escuchen al señor McDaniel y en solo un minuto veremos si tienen alguna pregunta.
Your Honor, I spoke to both defendants. They're going to plead of no contest to the charge as listed in both complaints.
Su señoría, he hablado con ambos acusados. Ellos se van a declarar no me opongo ante los cargos en ambas denuncias.
Understanding they'll be sentenced to 2 days jail, credit for 2 days, $370 fine, which would be a civil judgment.
Entendiendo que se les va a condenar a 2 días en la cárcel con crédito por los 2 días que ya han cumplido y tendrían una multa de $370 como un fallo civil.
They understand that any plea can be used against them in any immigration proceedings. They've also waived
Ellos entienden que ellos entienden que cualquier acuerdo al que hayan llegado en un caso penal se puede usar contra ellos en un caso de inmigración y han renunciado a un juicio.
That's above the honor.
Is a withhold adjudication, Mr. McDaniel?
Yes, Your Honor, withhold adjudication.
Le estamos suspendiendo el fallo de culpabilidad, señor McDaniel. Sí, su señoría, se le suspende el fallo de culpabilidad.
Mr. Mitchell's that agreeable with the state?
It is, Your Honor.
Señor Mitchell, ¿está de acuerdo el Estado? Lo está su señoría.
Mr. Villagran, did you hear that agreement?
Señor Villagrán, ¿escuchó usted el acuerdo?
Sí, un poco no he entendido, pero escuché.
Yes, there was some things I didn't understand, but I heard.
Okay, tell me what you understand the plea agreement to be, and we'll see if we're on the same page or not.
Bien, dígame lo que usted entendió que el acuerdo es y veremos si pensamos lo mismo o no.
Cuando yo renuncio al juicio, no entiendo qué es lo que, a cuál estoy renunciando.
When I'm waiving the right to a trial, I don't understand what it is that I'm waiving.
Okay, you have the right to a trial in front of a jury.
Usted tiene derecho a tener un juicio frente a un jurado.
But you can't have a trial and accept a plea agreement.
Pero no puede tener un juicio y aceptar un acuerdo.
Because if you accept the plea agreement, there will not be a trial.
Porque si acepta el acuerdo, no va a haber un juicio.
So when you say you're waiving your right to a trial, that means you would rather take the plea agreement than go to trial.
Cuando está diciendo que está renunciando a un juicio, está diciendo que prefiere aceptar un acuerdo en vez de tener que ir a juicio.
The plea agreement in your case is 2 days in jail with credit for 2 days you've already served.
El acuerdo en su caso son 2 días en la cárcel con crédito por los 2 días que ya ha cumplido.
Any other parts of the agreement you don't understand?
¿Alguna otra parte del acuerdo que no entienda?
No, es entendido. Lo único que para el caso de migración yo tengo mi abogado. Entonces eso sería otro caso.
No, I've understood, but the thing is, I have an attorney for immigration, so that would be another case.
Another case, another judge, another court. Yes, sir.
Otro caso, otro juez, otra corte. Sí, señor.
Entendido.
Understood.
Is this the plea you would like to enter to resolve this case?
¿Es este el acuerdo que desea aceptar para resolver este caso?
Sí.
Sí.
Yes.
And Mr. Teal, did you hear the plea agreement in your case?
Señor Tiul, ¿escuchó usted el acuerdo en su caso?
Sí.
Yes.
Do you have any questions about that plea agreement?
¿Tiene alguna pregunta acerca del acuerdo?
No, en caso de que todo está de acuerdo, nomás de que con tenemos el abogado.
Your Honor, may the interpreter request clarification?
Yes, sir.
Cuando dice tenemos el abogado, ¿se refiere al abogado de inmigración?
Sí.
Okay. No, I understood everything. We have an immigration attorney.
Okay, so is this the plea you would like to enter in the fishing case?
¿Es este el acuerdo que desea aceptar en el caso de la pesca?
Sí.
Yes.
Contest, Mr. Villagrán.
Señor Tiul, acepto su declaración de no me opongo y también acepto su declaración de no me opongo, señor Villagrán.
Both pleas are to 2 counts of taking game fish by illegal method.
Ambos tienen 2 cargos de tomar peces de forma ilegal.
In each case, I'm going to withhold adjudication of guilt.
En cada uno de los casos le suspendo el fallo de culpabilidad.
And sentence each of you to 2 days in the Jackson County Jail concurrently. That means running at the same time.
A ambos los condeno a 2 días en la cárcel del condado Bay simultáneamente, o sea que transcurren al mismo tiempo.
Each of you have 2 days credit.
Y los 2 tienen 2 días de crédito.
I'm imposing court costs and fines in each case, in count 1 of each case of $370.
Le estoy imponiendo una multa de $370 en el cargo 1 a ambos.
I'm going to waive the court costs and fines in the second count for each of your cases.
No les voy a imponer multa en el segundo cargo a ninguno de los 2.
So each of you has 1 court cost and fine of $370 that will become a civil judgment.
Así que cada uno de ustedes tiene una multa y costos de $370 que se convertirán en un fallo civil.
The immigration will be notified after court that they have 48 hours to pick you up.
Después de la audiencia se le notificará a inmigración que tienen 48 horas para recogerlos.
Mr. Villagrán, do you have any questions?
Señor Villagrán, ¿tiene alguna pregunta?
No.
No.
And Mr. Teal, any questions?
¿Y señor Tiol, alguna pregunta?
No.
No.
Wish you the best, gentlemen. Have a good day.
Les deseo lo mejor, señores. Que tengan un buen día.
Gracias, señor Ricardo.
Thank you, Your Honor.
We have LeQuentin Knight next. Knight, Mr. Camp, that you've had a chance to speak to Mr. McDaniel about that process. Mr. Knight, you just signed something, I believe, in front of me. I'm assuming that was a waiver of extradition. Is that right?
Yes, sir.
Mr. Knight, do you have any questions about that process?
So I was just trying to see. I ain't been in jail in a good 4 or 5 years, so I'm trying to wonder what it is.
Let me see what information sometimes they send us some information detailed and sometimes they don't. Let's see. Corporal Corporal, while I'm looking this up, do you have anything specific on what Houston County wants him for?
It's a failure to appear warrant only, no, sir.
Mr. Knight, the warrant doesn't say, the teletype from the agency doesn't say, it just says it's a failure to appear warrant out of Houston County, Alabama. So Mr. Knight, they have 30 days to pick you up, but I'll see you in 15 days if you're still here to see what's going on with the transport. With Houston County, Mr. Knight, that's pretty rare. Usually Houston County is going to pick you up within a week. My guess, this is a guess, my guess is they're going to pick you up this week, get you back up there. But if you're still here in 15 days, you'll come to first appearance and we'll get an update, okay?
Yes, sir.
Wish you the best, sir. We have Kristen Hicks next. Ms. Hicks, good morning. Ms. Hicks, you're here because you've been accused of one count of battery domestic violence. Ma'am, I have read the complaint. There is probable cause, Ms. Hicks. And I'm looking at your criminal history now. Ms. Hicks, have you ever been arrested or charged with a crime before, ma'am?
No, sir.
Yeah, I don't see anything at all. You work at Pizza Hut?
Yes, sir.
Ms. Hicks, let me see if the attorneys have any additional information they want to make sure I'm aware of before I address your bond or your release status. Mr. McDaniel, anything?
Your Honor, we just asked for some kind of, reasonable monetary cash bond. Also, she works at Pizza Hut and so does her boyfriend that she's pregnant with, having a baby with. I advise her, I think her boss, she said would work with them and try to put them on different shifts. But they both work at Pizza Hut, but she has no problem. She can comply with the no contact. Just let the court be aware that they do both work at Pizza Hut.
Thank you. Ms. Hicks, do you live together?
Yes, sir.
Okay. So Ms. Hicks, you're going to have to find somewhere else to go on a temporary basis if you live together. You have somewhere else you can live, ma'am?
Yes, sir.
Where?
My boss's house, more than likely.
Your boss is going to let you move in with him or her?
Yes, sir.
Okay. Mr. Mitchell, anything from the state?
I know there was a request for a possible cash bond regarding this, regarding her. We're not in objection to it.
Ms. Hicks, I'm gonna let you pick between a cash bond of $250 or a conditional release. I'm gonna offer you the conditional release because of your criminal history. Either way, you will have a condition, no contact with the alleged victim at all. If both you and he won't contact, ma'am, we'll deal with that if it happens, but right now, no contact. So you've got to go somewhere else on a temporary basis. Ms. Hicks, do you have any questions about the choice between the bond and the release, ma'am?
No, sir. I'll probably just do the cash bond.
It's $250 cash then. You'll get a chance to use the phone in a few minutes, ma'am, to post the bond. I'm going to ask the jail to give you a notice for your court date, which should be August 31st at 9 a.m. will be your court date. Miss Hicks, they're going to give you that notice. They're going to put that notice in your hands. You will not get a copy mailed to you. So the one they give you will be the only notice you get for October 31st. Excuse me. What date? August 31st at 9 a.m. Don't lose that. That's the only notice you're going to get. Any questions?
No, sir.
Have a good day, ma'am.
Thank you.
Okay. Mr. Holloway, good morning. This is State versus Otis Holloway. Mr. Holloway, give me a second. I ran out of time in your case. I didn't finish reading the complaint. So let me finish that and look at your criminal history. Give me just a minute to do that. Mr. McDaniel, I have not looked at the statute yet on the abuse of a disabled adult. Do you want me to look at that? You want me to be heard on probable cause, or do you agree there's probable cause there for that particular charge?
I thought that was probable cause, Your Honor. I didn't have any objections with it.
All right. So there's probable cause. I just don't know the specific elements of that case of that statute. So, Mr. Holloway, I'm going to find there is probable cause for the offense. I'm going to listen to the attorney, sir, and we're going to go from there. Mr. McDaniel, anything on behalf of Mr. Holloway?
Your Honor, we just asked for, reasonable bond.
Thank you. Mr. Mitchell?
In addition to the standard conditions he will be given, we also request he be ordered not to possess or consume any alcoholic beverages. There was an allegation that he had been drinking that morning, so we think it's in the best interest that he not be allowed to possess or consume alcohol.
Thank you both. Mr. Holloway, I don't see any charges pending. You've got multiple prior charges, but I don't see anything pending. Is that correct?
Yes, sir.
And I also don't think you're on probation. Is that correct?
Yes, sir.
That's good, because that means you're entitled to a bond then. So, Mr. Holloway, I'm going to go ahead and set your bond. I think these are all third-degree felonies. Your bond's going to be $5,000 each. Mr. Holloway, your bond is $15,000 cash or surety. Cash or surety means you don't have to come up with all the money. You can go through a bondsman. That's what a surety bond is. Mr. Holloway, you have a condition of no contact with the alleged victim, Ms. Stevens, I believe is her name, and you also have a condition not to possess or consume alcohol. Mr. Holloway, you will get to use the phone in a few minutes, sir, to try to post the bond. Just stay away from the alleged victim while this thing gets sorted out. You also will be given a notice from the jail staff for your court date, which will be September 1st in the circuit courtroom, and that'll be in front of Judge Garcia at 8:30. September 1st at 8:30 will be your court date. Mr. Holloway, do you have any questions?
No, sir.
Wish you the best, Mr. Holloway. Mr. McDaniel, that was it on my list.
We got Eric Aguilar, the land pain. He was charged with petty theft, second misdemeanor and violation of state probation, and they bring him back for a 7-day hold.
I missed that totally, the way it was. Yeah, they did it in a different order they normally do it. So it's on the back sheet. Let me find that file then. So, Mr. Aguilar.
Yes, sir.
You've already been first appeared on the petty theft and set a bond. It looks like we did a 7-day hold on you. I just need to find out if there's a warrant issued or not, or if not, if there's not. What county was it, Mr. McDaniel?
Jackson County.
Really? It's unusual. Let me check the portal to make sure there's not one sitting there waiting.
He was just arrested this weekend, Judge, so.
Well, how is he back on a 7-day hold if he was just arrested this weekend?
I guess he's being brought here to address that there's a 7-day hold.
To place a 7-day hold.
Oh, okay.
Okay, so thank you. That makes sense. That makes more sense. So, sir, what we do in Jackson County, actually about 4 or 5 counties in North Florida, is instead of just holding you indefinitely, we try to put a burden on the probation office to kind of get them to moving, and they do a very good job of doing it. When we do this, we put a 7-day hold on you. That way you're not sitting there indefinitely. They have 7 days to seek a warrant. And that doesn't mean they can't seek a warrant after 7 days. It means we're not going to keep holding you with no bond for after 7 days. So they have 7 days. That 7 days starts today, because today is the first day they can be notified. So I'm asking Mr. Mitchell to notify the probation office of your arrest, and I will see you 1 week from today on Monday. Now, let's say they get a warrant before then. Let's say they get a warrant tomorrow. If that happens, I very well may see you tomorrow. The judge that reviews that warrant will be the person to decide if you get a bond or not. I have no idea if you'll get a bond on the VOP. A lot of times you don't get bonds on VOPs if they're based on new arrests, but that'll be another judge's call. So I'll see you when the judge reviews the warrant. We'll see if there's a VOP warrant or not, and we'll go from there. Do you have any questions?
Yes, sir. I want to know if I can plead no contest to this misdemeanor charge.
We didn't make a tentative offer on that one, did we?
No, Your Honor.
Mr. Mitchell, was there an offer made at first appearance the first time, or was another judge covering? Oh, it was this weekend, so yeah, it had to be a different judge. Mr. Mitchell, have you looked at the complaint? You want to make an offer, or do you want to bring it back tomorrow to try to see if we can resolve that?
Give me just a minute. Let me look at it again.
Oh, you're doing that. I'm gonna look at his history also.
That'll probably be helpful.
He's on probation for felony petty theft. Got a new one. Let's see what the amount is. Yeah, so
Given amount of what was stolen, they just said various merchandise and items.
So two things. If you would please contact the officer. If they don't give us an amount, we have to assume it's second degree misdemeanor, lowest degree crime Florida has. So they need to put the total amount of the item stolen in the complaint. Every time they should do that. So please contact the officer in this case and ask it in the future that he include that. So given that he's charged with a second degree misdemeanor and he is already on probation for the same charge, do you have a tentative plea that you would like to make?
I think we go 60 days jail
And
with
so-
the standard conditions we usually do for every VOP case.
Mr. Aguilar, if you want to resolve this case today, your offer would be 60 days in the Jackson County Jail. That's the maximum for the charge the officer has accused you of so far. Now, let me kind of explain. I have no idea what was stolen or the amount because the officer didn't tell us that. So that is the maximum for that charge because you're already on probation for a similar charge. Now, if you want to take the offer, that's fine. If you don't take the offer, I don't know if the officer can amend it or not. If the officer amends the complaint, it's over $100 in value. It becomes a first degree misdemeanor, which means it carries up to a year. The plea offer may change. If it's less than $100, it can't change. It's going to be the way it is right now, unless the state decides to take it to felony court. If you have multiple priors, they may be able to do that. If you want to resolve it today, it's 60 days in jail, but you don't have to do that. You have any
That's fine.
questions?
Yes, sir. I'll plead no contest to the 60 days. I'll take that.
Okay. Listen to Mr. McDaniel. He's going to explain it to you. Make sure that you don't have any questions.
Okay.
Your Honor, I spoke to Mr. Aguilar before, so he's going to go ahead and enter a plea of no contest with the understanding he'll be sentenced to 60 days in the county jail, $370 fine. You have 2 days jail credit. This plea can't be used against him in the violation of state probation. However, the incident itself can be used by calling witnesses. He is going to waive his right to a jury trial and call witnesses. Actually, he already has waived his right. So, and this will resolve this case today.
Thank you. Mr. Mitchell, is that all agreeable with the state?
It is, Your Honor.
Mr. Aguilar, did you hear that agreement?
Yes, sir.
And do you have any questions about that agreement?
No, sir.
Is that the plea you would like to enter to resolve this new charge?
Yes, sir.
Mr. Aguilar, I'm going to accept your plea of no contest to the charge of second degree misdemeanor petty theft. I'm going to judge you guilty of that offense. I'm going to sentence you to 60 days in jail, give you credit for the time that you've already served, which is 2 days in jail, 370 court costs and fines imposed. The complaint does not allege any restitution amount. And there's a condition that the plea will not be used against you in the VOP proceeding. If they try to use this plea against you, I will let you withdraw this plea. But as your attorney just said, they still may be able to use the incident against you. Mr. Aguilar, you have 2 days credit, so you've got 58 days left at most. So I will not see you in 7 days now. And the reason I won't is you're going to be there longer than 7 days.
Yes, sir.
So you've got your sentence. If they get a warrant for you, then we'll see you when they charge you and serve that warrant on you on the VOP. If they don't get a warrant for you, then you're going to be released when you finish the sentence. Any questions, sir?
No, sir. Thank you so much.
Yes, sir. Wish you the best.
All right.
Mr. McDaniel, I did notice this on the second page of VOCP with no bond, but I think that case has already been resolved and sentenced. So I don't know if that's actually accurate. Mr. Barrentine's already been sentenced. Anything else, Mr. McDaniel?
Nothing else, Your Honor.
Corporal, anything else from the jail?
No, Your Honor.
Alrighty, hour 2 of TCF Live on a Monday. Thank you all for being with me. My name is Dan. If you're new to the channel, please do say hello in the chat if you haven't already. We're a friendly folk around here. You'll like us. Alrighty, let's go to Texas. Judge West Monday Morning Fashion Show. Let's see how that's going.
Good morning, ma'am. Are you LaCaria Kirkwood? And Ms. Kirkwood, this is your initial appearance in cause number 26 DCCR 1191. You're charged with a state jail felony offense of criminal mischief, and that's from April 20th of 2026. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer? So what I'm going to do, Ms. Kirkwood, is reset your case about 30 days to give you some time to try to hire someone. If you get someone hired before that next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would have to go back to jail. Do you understand? All right, if you'll step in front of the clerk right here, she'll give you a reset notice.
Michael Groff, thank you for gifting a membership. I appreciate that. For those of you who are new to the channel, Michael Groff is somebody you need to check out. He's way better at this whole YouTube thing than I am, but he's also a broadcast professional, so he should be. But do check him out. Barbara, if you drop a link to Michael's channel, I'd appreciate that.
Good morning. Are you Horace Tyson? And Mr. Tyson, this is your initial appearance in cause number 26, DCCR 1250. You're charged with the second-degree felony offense of aggravated assault with a deadly weapon, and that's from April 17th of 2026. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
Okay, I can't afford it.
Okay.
But,
Are you unable to work?
I'm able to work.
I'm sorry.
I'm able to work.
You're unable. So I'm going to find Mr. Tyson that you qualify for a court-appointed lawyer. And we'll get that name for you this morning. And the clerk will give you those instructions. All right. So if you'll just come in front of the clerk for a second, she'll give you that information. Yes, ma'am. Yeah, the one that was appointed when you were in custody is going to be who your attorney is. Okay. Hagen Downhauer. Hagen Downhauer.
No, I have a check line here.
Okay, what, for now, I'll do a bond forfeiture for non-appearance, reset her, bond at 100,000. If she comes back, maybe she went to the restroom, just let me know. And then that Damien Hurd, he's still in custody from the weekend, Kelly? Damien Hurd.
Damien Berg.
Do you know what the new one is? Good morning. Are you Damien Hurd?
Yes, ma'am.
And Mr. Hurd, were you able to get a lawyer? What were you arrested for this weekend?
Unlawfully here in the bills.
Okay.
But you know, I'm kind of confused. I went to the feds for that too. So I don't know what's going on.
You went to the feds for what?
For what they arresting me for over the weekend.
So was there a warrant or was it a new, something they just?
They said they indicted.
Oh, you did?
Yes, ma'am.
Let me look.
13.
Got it. Sorry, I didn't see. Give me just a second. Let me find out. Yes, sir.
I think I can probably explain. Legal issue we discussed in a different case in this court about a month or so ago. About the new federals on firearms. What I've seen is several where they've dismissed the Fed case and filed state cases. So it may be one of those.
So it looks like the offense date was from May 11th of 25.
Yes, ma'am. When I got indicted by the feds in November.
Okay.
The 5th.
Okay.
I had paperwork.
No, that's okay. I just see that. Thank you, Mr. Nichols.
And I don't know that that's happened in his case, but it's happened in several. So that may be why there's.
Why it's old, it's old case. So it's not like something just happened. They just came and found you and arrested you on that warrant.
I did 7 months, you know.
Well, whatever happened in the federal system, I have no say so over. Now you have a state case. And technically you can have both, which is kind of weird. I understand. But if they're not going to go, what needs to happen, obviously, Mr. Hurd, now on each of these cases is you need to get a lawyer. So that they can help you figure all that out. So, but last time, I gave you some time to try to get someone hired on that other case. Have you been able to get someone hired?
I ain't getting nobody hired, but I talked to,
Who'd you talk to?
Mr. Lane Welcome. He wanted to charge me $50,000. And I talked to Tony, everybody.
Can y'all hold it down just a little, please?
He wanted $5,000. I talked to Mr. Right.
Okay.
He wanted $5,000. I go see stuff on William Marcus Wilson on the 19th.
Do you think you're going to be able to afford any of those, or do you want to see if you qualify this morning for a court-appointed lawyer?
Let's see, but I think I'm gonna try to get.
You're going to try. Okay. So since you just had that new arrest, what I'll do is give you some extra time. I'll reset your case another 30 days to give you some time to see if you can get someone hired.
Yes, ma'am.
If you do, great. Just bring that reset notice to them. If you're unable to talk to whoever else you're going to talk to, bring me those names and then we'll discuss your options. Okay, step in front of the clerk. She'll give you a reset notice.
And Michael, thank you for 15 months with us as a channel member here at TCF. Become a good friend to me, guest host for the show, sidebar panelist, all the good things. I appreciate you, Michael. Thank you.
Michael was one of them, so this might be one else you said. And also,
Who else did you talk to?
Brian Burks, Senator Adams, and Thomas Burton.
Okay.
And also, it's my personal income.
Okay.
I think I was supposed to show. Just like the last.
You get paid weekly or bi-weekly? Weekly. Okay. All right. So you think if I give you one more reset, you're going to be able to get one of them hired? Well, thank you for bringing that and doing what I asked you to do, Mr. Kincaid. Let me take a look at something. So are you still working at the court?
Yes, ma'am.
You are?
It's been kind of hard for me because, me and my wife going through a separation and she didn't file like the postcards home, but they still let me know your card still.
You do still have your TWIC card? Okay. So I'm not sure what's going on between the two of y'all, but she sent us some information. She's obviously not happy with whatever's going on. If I were you, to stay out of trouble, I would stay far away at this point. Make sure you keep your job, keep your TWIC card, do everything you're supposed to be doing, and don't be doing anything you're not supposed to be doing. Some of the allegations she makes in here are not good about some selling drugs and all kinds of stuff like that. So if you're still working, I've seen your pay stubs. It looks like you are, so I'm going to assume that you are. Thank you for bringing that. You need to try to get someone hired before that next court date. All right, step in front of the clerk. Nelson Garrick. Nelson Garrick.
Nelson Garrett. Nelson Garrett.
Good morning. Are you Nelson Garrick?
Yes, ma'am.
And Mr. Garrick, were you able to get someone hired?
No, ma'am, but I'm trying to see if I have one in mind, but I didn't know if I wanted to show it with like switching. So I wanted to see if I could get I kind of found one, like, but he never gave me a real answer, like a legitimate number. And so we're working on it with my dad.
Who is that you talked to?
His name Crump, something like that. It's CRUMP.
Where's he out of?
Houston.
Okay.
Yes.
So is your dad helping you hire someone?
Yes.
So when you were here before, I gave you some rules to either get someone hired or talk to at least 3 attorneys.
Yes, ma'am.
So I need to know if you talk to some others or if you're planning on hiring him, I can give you some time, but you
Yeah,
gotta.
somebody kind of got in my ear about the last one, so I don't really want to do too much with it, but try to be.
So here's what I'm gonna do, Mr. Garrett. I'm gonna reset your case one more time. If you get Mr. Crump hired, great. If not, I'm ordering you to visit with at least 3 lawyers, all right? Not just your dad, but you or whoever needs to talk to at least 3. Again, they all charge different amounts, they have different payment plans. If you don't do what I've asked you to do next time when you come in, your bond's gonna be raised for not following that court order and you're gonna go back to jail. So make sure you do that, okay? Step in front of the clerk, she'll give you a reset notice.
Alrighty, friends, I will keep an eye on Judge West's court, but let's go across the hall to Judge Stevens, where the defendant approaching has earrings as big as coasters.
Yes. And it's okay.
Jamaica?
Yes.
Got evading detention, 3rd degree, and we've got the 1st degree felony escape. Is that?
Yes, sir.
Ooh, that's the one that's going to sting.
Judge, we're actively trying to get this matter resolved. I've spoken with Mr. Laird very extensively last week.
566 days old.
I know, Judge.
So what are we going to do today?
We're not doing anything today, Judge, if that's okay.
Doesn't get things done.
A new offer was made last week, Judge. Ms. Bugler and her family to come by my office next week to discuss.
I went to the complaining witness who's a police officer and he gave me an okay for a new offer. So we made it and
I'm just reset this 2 weeks.
Yes.
Or earlier if you want.
No, 2 weeks fine, Judge. 2 weeks, Judge. Just gives me enough time to speak.
Here, Lace, on this one, on Butler. Thank you so much. All right. Right. Kendrick Leday.
You skipped.
I know I did. I just want to get your reaction. Okay, Ryan McGowan.
Here, Judge, I am here on that first case, Kendrick Malcolm, that we were just speaking about though. So I don't know that I would be ready on his case today, given the other client that I had before.
You're always ready. You're be prepared. You're as good as count. But it's 500 days on it. Right?
And then I have that doctor's appointment issue tomorrow.
So still in the doctor's appointment on.
Yeah, let's throw that in.
Is this one's certain to get tried? Is it? It looks like
Mike saying
she
that.
jumped on something there.
I would love to try to work it out, but I don't know. I think we might be
Well,
too far apart.
have y'all
right now.
tried just to see if it's possible? Maybe why don't you throw that out and just see if it's possible? If it's not, that's why we invented a court. Yeah, and 620 jury trials. We tried another world record according to the internet.
Set it for a couple of weeks for a review to see.
2 weeks.
Yeah.
For
Then we'll
review.
see if we can
Good.
talk.
Thank you. Here. And Jazz Young.
She's a dismissal judge.
Okay, I'll sign it when it gets in the pad. Okay.
Tell me when it comes in there.
Yep, it's there. Where's Jasmine?
Right there. Okay.
Oh, good sneeze. Okay, there's a motion to dismiss here.
Yes, Your Honor.
Jasmine.
I've spoken, sorry to interrupt the court. I've spoken with the
That's
lead.
okay. I got used to it.
I've spoken with the lead detective judge and we're on the same
Okay.
page.
Oh, your word's good enough to me.
Thank you, Judge.
Can you go on more on the explanation though?
That's all I have, Judge.
All right. That case is hereby dismissed. And don't commit crimes. Okay. You can go. Good. I can't believe it's the 17th already. It's time looks down
I know.
when you're having fun of it. Okay, Jasmine Young is hereby dismissed.
Thanks, Judge.
Thank you, Judge.
I have a Megan Wilcoxon. If there's no disagreement on that one, I'm going to sign that 24 CR 1788. What did John say?
No objection. Somebody else can
Yeah.
Okay.
That case. 25 CR 363. That was dismissed. Then 24 CR 1788, Megan Wilcoxon, that is hereby dismissed. And then I have Bruce Smith's Kendrick Leday. And once again, I guess that'll follow up with the earlier one. That's going to have to be reset for illness. Rodney Wells, John. This one,
same announcement. I was like, it's winning.
This one's going to go to trial? Come on, it's a family thing. Got to fix the family here. You got to fix the family.
Yeah, I mean, we can. It's one I can be ready on if we.
All right, but when they're ready, and Xing Shang Yang, just yeah. What are we going to do on that one?
Well, my paralegal is not.
No felony thefts ever get tried here. That's weird.
Yeah, well, this is the case as a co-defendant that was
It's a lot of money, though. Looks like in the indictment.
Was
Oh, I've highlighted it too. All right.
It was reset last week because there's on the cell phone dump the.
Oh, still working on that.
Yeah, apparently it's not readable. At least it wasn't by the co-defendant. I don't know if this gentleman's looked at his or not, but I can't open up mine, so we're getting an additional copy.
What do you want to do today? How many?
Talking about
The cell phone dump as to both individuals.
so 2 cell phone dumps.
Yes, sir.
I thought there was only one being.
Okay. I'm just reset this, right?
We also have a motion withdrawal.
I have no objections.
We've been going back and forth with the client about payment for trial fees. Currently, we're at $0. So we, and as well, just put a firm that retained on this case.
All right, I need Yang, Mr. Yang out. Where's Mr. Yang? Come forward.
My paralegal's on the way. He does not speak English.
Let me know when.
Absolutely.
Paralegal does?
Yes, she speaks
Speak.
Mandarin.
Okay, Mandarin. Only the #1 language in the world. Okay, stand by. Let me know when they get here. So we've got Brandon Charles, Keto Means, Rodney Wells, 1, 2, 3. Good. It's done. Thank you. Here.
Each warrant will be tried. He has several warrants. It's on the last page.
The trial bundle?
Of your regular document.
Alrighty, friends, halfway through TCF Live already. The morning is flying by. Let's head back up to Michigan, check back in with Judge McNally. We'll come back to Judge Stevens when he actually has somebody in front of him.
You are going to plead responsible to impeding traffic, right?
Yes, sir.
You got to be careful here. You had a couple other issues recently to that charge of impeding traffic. And that you caused an accident here, according to them. Responsible or not responsible?
Responsible.
I'll accept the plea. 210's your total. You can go down the hall and take care of that.
Man, hey, by September 1st.
Huh? Okay. I'll give you till September 1st. Okay? If you don't have the money, you call the court. We'll go on Zoom, or you can walk in here on it before that due date and they'll give you an extension. All right?
Thanks, sir.
Good luck. Miles Nicholson, 260-649-051. All right, sir, your name? You're going to plead to impeding, right? Responsible or not responsible to that? Okay, I'm gonna accept your plea, 150, cash your end of the hall to your right, and you're all set.
Thank you.
Good luck. Zachary Taylor, 260-649-116. Could I have Joshua Miller and El Bahia seated over at the table over here, please? Mr. Taylor, your name?
Zachary Taylor.
You're going to plead to impeding traffic, correct?
Yes.
Responsible or not responsible to them? All right, I'm gonna accept your plea. 160 is your total. Cash your end of the hall to your right. You're all set. Good luck.
Thank you.
Joshua Miller, 260-648-896. Your name?
Joshua Miller.
All right. No injuries, no vehicles towed. You caused an accident. You're going to plead to impeding traffic, right?
Yes, sir.
Responsible or not responsible to that?
Responsible.
All right, 205 will be your charge. You can go down the hall and pay that and you're all set. Good luck.
Thank you.
Multazar El Bahia, 26B151165. He failed to appear. He's responsible as charged by default. People against
Judge, what was the
Francis.
name of that one? I have someone in Zoom. I just want to make sure it's not this person.
Multazar El Bahia.
Oh, no.
Okay, so I'm gonna read a default judgment. Francisco Elijah's Cantu, 25F2447628.
Judge, good morning.
Good morning.
P-Tech Lindsay, and we have Francisco Cantu.
Good morning, counsel. You got your work cut out for you in this one. Your name?
Francisco Cantu.
All right, so I ordered, what happened is you guys were in here. There was a plea of guilt on July the 20th. And the other charge was that you stipulated we'd treat OWI conviction as to count 2, a non-technical, and R&O as to count 3. And we treated count 1 as a technical violation, which was consuming alcohol. I ordered him on a sober link at that time. And then I have, and your name is O'Donnell? It says on August, so she said, see attached screening and police report regarding the new charge. You ordered for him to obtain did you get a chance to see this? This report that she did, prepared in the file?
No, Judge, I didn't. If it's just a.
Here, I'll just read it to you. It says you ordered for Mr. Cantu to obtain a SoberLink device on July 20 when you last saw him in court. He did obtain the device on August 9. There was a positive blow on the SoberLink device at 6 p.m. with a result of 0.046, and then he failed to comply with the retest blows as follows on August 9th at 6:15, 6:45, 7:15, 7:45, 8:15, 8:45. And then she wrote, she added on August, today it looks like, right? August 17th, over the weekend, the defendant tested positive on a SoberLink device and failed to comply with the retest blows. On August 15th, positive blow on SoberLink device at 6:25, and then failed to comply with the retest blows. So we've got 3 instances, correct me if I'm wrong, 3 instances where he tested positive and then didn't follow up with the retest.
So it's August 9th, there was an incident, and then August 17th was the incident.
I see. My apology. I thought you were adding that on the 17th. So we've got 2 of those. So we're here for sentencing. I'll listen to anything that you have to say and we'll go from there.
Judge, if you recall, you also ordered my client to get into an IOP. And you ordered my client to finish community service. He finished his community service, and for both the case up north in Standish as well as this one, he was not able to get into IOP because he doesn't have any insurance. To his credit, I gave him a lot of places, and I believe that he called them trying to get those done. Judge, he's paid in full, and the SoberLink it's unfortunate, and it tells me he didn't drink. Obviously, we all like to believe that. It would have been real simple.
Well, I'll give him a hearing on that if you want.
No, Judge, just what I'm saying is.
No, wait, let's slow down.
Yeah.
If he says he didn't drink, I'll be happy to give him a hearing with respect to the SoberLink blows on August the 9th and August the 15th. I'll be happy to do that. That's not fair for me not to give him a hearing. If he's going to deny that he drank, let's have a hearing. If he isn't going to deny that he drank, then he can plead guilty to it. But I'm not going to proceed on the basis that he drank or didn't drink if he's denying that he drank. Right?
Understood.
So what does he want to do? If you need time to confer with him, I'll be happy to listen.
I don't need time to confirm. Can I approach with Mr. Donald briefly?
Yeah. Pull up the record.
Thank you.
You got a couple. Keep going, baby.
No.
He's either gonna have a hearing on these 2, or he's gonna make guilt on these 2. And so I'm gonna do it.
That's what I'm approaching about.
I have to tell you.
I know.
I do too.
Oh no, Judge. I'm coming up here to let you know that we're not gonna play this game. My client, he's adamant. Didn't follow the rules of the slop. He did get into the aisle. And that's it. If you'll take those, he's going to admit to violating his probation, and you're gonna do what he's gonna do.
But he's gonna have to.
Oh, you want to hear him concerned about me?
He wants to have a hearing.
No. Okay, no, I don't think he's gonna do that. I don't think he wants to do that. He was adamant about it with me. What he didn't do was he didn't follow it. All he had to do is sit around and do the retest. That's what
He's gonna have to be dragged.
okay. Understood. Then I'll let him, Judge, I get it. But I mean, my client is ready to accept responsibility, go to the max. So what do you have at your disposal? Which I think is,
Well, that,
and he knows that.
that's fair. But he's gonna have to be dragged.
Judge,
here.
That's what I approached. Let's pass it for a minute so
No
I can
problem.
talk to him.
Thank you.
Appreciate you.
Thanks.
Yep.
Madeline, let me call you later. Wherever you are back there, I saw you. Let me call you later, okay? Alex Trebizio, 26W843982. Your name, sir?
Alex Rizio?
You're gonna plead to impeding, right?
Yes, sir.
Responsible or not responsible to that? All right, please accept it. 170 is your total. Cash your rent at the hall to your right. You're all set. DeAndre Buford, 26W843781. All right. Your name? All right, so you're gonna plead to 1 to 5 over, right? You gotta slow down and be careful. First of all, you can't be driving on a revoked license. Second, your record is like horrible. Why are you driving like this?
Well, I was only driving for about 5 minutes before.
I don't care. You were speeding. They got you going 38 and a 25.
It was slow traffic.
Sir.
I got over to.
Sir, you're gonna plead to 1 to 5 over?
Yeah.
Responsible or not responsible for that? Listen to me very carefully. You're never gonna get your license back if you keep driving. You cannot drive on a revoked license. You know what a revoked license means, or a suspended license, right?
Yes, sir.
Your record looks horrible. I appreciate you dressing up, shows respect. I appreciate that. Can't drive on a revoked. Your record is just horrible. 190. I'll dismiss the original charge. You're all set. Cash your into the hall to your right. Good luck. Lori Rolak, 26W843974. Ma'am, your name?
Lori Roller.
You're gonna plead to impeding traffic, true?
He did not let me know that. I was the one that.
Are you good? Are you good with that? You want to plead to impeding traffic? It won't go on your record at 0 points.
There we go.
To that charge of impeding traffic, responsible or not responsible? Please accepted 160 total. Yeah, you're in the hall, you're right. Good luck. Rachel Briggs, 260-649-115. Ma'am, you're going in the lockup. Don't go in there.
You know, they're like. We're like.
Good morning. Your name? You're going to plead to impeding traffic, right? Responsible or not responsible?
Responsible.
Please accepted. 150 is your total. Cash your end of the hall to your right, okay? Have a good day. Kimberly Smallwood, 26B151075. Ivan Abram, I'm going to ask you to have a seat at the table, my right.
All right, it's very much impeding Monday in Judge McNally's court. I will keep an eye out for our allegedly Amish-looking friend. Let's go back to Texas Judge Stevens.
Oh, you're gonna get him in trouble. Y'all work as a team. You can do more damage that way. Okay, we've got Ricky Turner.
Okay.
And a 24 CR 2444, third degree felony, unlawful possession of metal or body armor by a felon. And then we've got a 2010. This is habitual felon.
That's right, Judge.
Yes. Because he's got these 2 prior convictions in sequence out of criminal district court in 2010 for illegal possession of a controlled substance. And then after that was
I'm gonna pause it just a second. Correct me if I heard it wrong. Did he just say unauthorized possession of body armor by a felon? Of all of the things I've ever heard, that one, if that's what I heard correctly, that one really strikes me as wrong. What exactly would be a problem with a felon possessing body armor, like the ability to protect themselves without like lethal force? There's nothing lethal about that. There's nothing inherently that says I'm going to go get crimey about that. I don't know. That one's weird to me. Correct me if you think differently in the comments, but I had to stop because that one hits me wrong. Anyways, let's continue.
Prohibited item in a correctional facility. I wonder, was that drugs maybe? I don't know. It's always a drug or a weapon. And that was out of the 415th Judicial District Court of Parker County, I guess where that prison is located. So on that case, you're looking at 25 to life, a minimum of 25 years in prison. You're not eligible for probation. On 26 CR 942, you're charged with a third-degree felony of illegal possession of cocaine, and you have 1, 2, 3 prior convictions alleged, and it looks like in sequence, all of those. So you were a habitual felon in that case, a conviction ago. When that 2014 illegal possession of a prohibited item in a correctional facility was finalized. So over 10 years ago, you were looking at habitual felon status. So you're twice a habitual felon. So you're looking at each case, no less than 25 years in prison to life in prison. And what were we going to be doing today, John, before we go to the next step?
We originally, I think, put the body armor. It's been on the trial docket before. Then these other cases came up since then, but originally we were going to try the body armor case. So I don't know if that's changed with all the new cases, but it's
okay. All right. But it's not going to be resolved.
Not right now, but I will talk to Mr. Coleman. I missed him last week. I was talking about this.
Well, the potato test news for you.
Okay.
Go ahead, Kendall.
We get 3 active warrants.
3 active warrants on him.
Evading arrest, theft of property, and failure to identify.
Your bonds are revoked in each of these cases.
Let's talk, John. Let's talk.
So, hold on. For the record, the bonds on these 2 cases, Mr. Turner, are hereby revoked. And they are doubled in each case. What were his bonds?
On the body armor case, it's 15,000. And the possession case, it was 10,000.
$15,000 and $10,000. And no, they're not doubled. They're $100,000 each because you are a habitual felon 1 conviction ago. Your criminal history is caught up with you, and your new criminal charges are not helping you at all. So you are at $100,000 in each of these 2 new cases. Where are these cases out of, these new cases?
Jefferson County.
Jefferson?
Misdemeanor court.
Okay. Yeah, well, you'll have to deal with bonds in those whenever they come around. All right, John, you want an announcement? Let's do an announcement in 2 weeks, find out what's the status and where he's headed. All right. That's that. Down left.
Making it look great.
It was a lawyer. He's there. Holly LeBlanc.
She's a plea judge.
Oh, great. Y'all were working on something?
We were trying, we were just chatting.
Oh, okay, cool. Thanks for letting me in on that. I could use some good scoop. Nobody ever tells me anything good. Just plead guilties. Those are depressing. Patrick Thomas?
I've got a couple of things I'd like to share,
No, thank you. I've got enough problems.
Okay.
Okay.
I'm not sure what Mr. Thomas is gonna do just yet.
NPRP.
I need to speak with.
Okay, all right, let me know. Timmy Turner.
I need a reset on him, Judge.
Sure.
We're,
How much
yes,
time?
4 weeks if possible.
Well, he's in there.
Yes, he is.
Hey, Mr. Coleman, on Timmy Turner's, and we're going to reset 4 weeks at Reagan's.
Yes.
Request.
Yes, sir.
Done. Okay, all right, you got a plea?
Holly LeBlanc, yes, Judge.
Holly LeBlanc. Hollywood. All right, I need Holly. Holly LeBlanc in the queue. It's exciting. Get things done.
Very well.
Thank you. Mr. Negativity.
Some call it realistic.
Well, that's because what's real is very negative right now.
Yes, sir.
All right, we need Holly LeBlanc, please. She's coming.
Oh, trust agenda, please.
Holly LeBlanc, that's you. Does she need to swear? No, wait, swear in front of that lady right here, Miss LeBlanc. That lady, thank you. And then,
Swear or affirm, tell the truth, the whole truth, and nothing but the truth, so help you God. Speak of your right tongue, like a flat on your mouth. There's one more time. Flat right outside the box, right on top.
and you are Holly LeBlanc. Correct. You're here with Miss Nava, your attorney, the state's attorney, and the probation officer is here. You are on probation, and this is cause number 24 CR 289. And you are Holly LeBlanc. And that's yes?
Yes.
Great. There is a motion to revoke probation that was filed, my goodness, a year ago.
Yes, Judge.
Well, we're about to finalize it. It's more than enough time has gone by here for it to move forward. Does the defendant waive a formal reading of this? Can we proceed in summary?
Yes, Judge.
And raise your right hand, ma'am. Do you solemnly swear or affirm that any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Lower your hands. In summary, Ms. LeBlanc, this motion to revoke probation states that on May 23rd of 2024, which is 2 years ago, my goodness, in this criminal district court of Jefferson County, Texas, you were sentenced to 2 years in the state jail, and that was suspended. You were placed on regular probation for 5 years for a state jail felony of theft of property. Is that true?
Yes, sir.
Got allegation 1, committed the offense of illegal possession of a controlled substance in Orange County.
Judge, that's still pending.
Is that
but
yes, no?
2 and 3 are
2,
yes.
2 states you committed the offense of criminal trespass on or about April 27th, 2025 in Orange County, Texas, in violation of condition 1 of your probation order. Condition 1 of your probation order states you shall commit no offense against the laws of this state or any other state or of the United States. And so, since Orange County is still in the United States, is that allegation true or untrue?
Yes, sir.
Are you pleading true voluntarily and because it is true as it is alleged?
Yes, sir.
Do you understand that a voluntarily and knowingly made plea of true to 1 or more violations of probation, that's enough to grant a motion to revoke probation?
Yes.
Your probation can be revoked. You can be sentenced to no less than 180 days up to 2 years in the state jail. Knowing that, do you insist on pleading true today?
Yes.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. Is this going to be good enough for us to move forward? Or
Yes, sir. It's fine.
Nelson doesn't need to interject. Okay. First. Thank you. But they lost, said, I need to read all verses. Use it, not use this. Yeah, he's in spending the rest of his life and places that he wants to try. Yeah. Yeah. I understand. The marriage house, sometimes I have those. You're trying to not. The Democratic. Someone said.
I am looking at the paperwork regarding the agreed punishment recommendation, and there is a recommendation that upon your plea of true that you have made here, that your probation would be revoked, you would be sentenced to 1 year in the state jail. Is that your understanding of the plan? If I follow this, you have no right of appeal of your case. Do you understand? I'm showing you what's marked as Stacy Exhibit 1. Did you sign that? Understand it? Discuss it with your attorney? Is everything true and correct? Stacy Exhibit 1 tendered into evidence without objection admitted. And this states that you are mentally competent to enter your plea today, and it is voluntarily and freely made, and you are waiving all other rights under the law, and you are waiving your rights of appeal, and that you are totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God.
Yes.
States Exhibit 1 is made a part of the record for all purposes. I will follow this agreement. If nothing further, I will find that you, Ms. LeBlanc, have entered your plea of true to allegation 2 of this motion to revoke probation. That is admitting to committing the offense of criminal trespass on or about April 27, 2025 in Orange County, Texas. The court finds this is a violation of condition 1 of your probation order, which states commit no offense against the laws of the state, any other state or of the United States. And that is enough to grant this motion to revoke probation by a preponderance of the other third graders. Your probation is hereby revoked, and I am following this agreement. You hereby sentenced to confinement in the state jail for 1 year. You understand this happened today. Do you have any other cases pending in any other courts?
I have one in Orange County.
Orange County. It must be the theft or something, or this
Possession.
Oh. Because I'm looking at theft of property, April 27th, it's alleged out of Orange County.
That's
And
out of
then
the same
illegal
facts.
possession of a controlled substance in March out of Orange County. Met that fact. All right. Okay, well, you've got still work to do there. Anything else to add to you? That is all. Thank you.
About to enter hour 3 of TCF Live on this Monday. It is good to have you all here. Again, my name is Dan. If you are new to the channel and you have not yet said good morning, do say good morning to us in the chat. You'll like us here. We're nice. Program reminder, second session today, 2:30 p.m. Eastern, 11:30 a.m. Pacific. I've got a good lineup for you today, including a case where there was a jet ski collision that involved a minor. So that is quite interesting. So do join me for that, 2:30 Eastern, 11:30 Pacific. Let's go back to Judge McNally.
All right, so we're gonna have to, let me just recap again. Ma'am, your name? So she put on 240, she pled guilty to failure to clear all warrants, that's count 3. Failure to pay all fines and costs, count 2. Failure to report on May the 11th of 26. And I set a sentencing date on that first I said it for July 20, I said she was, they're all warrants by then. And then she came in and she hadn't, and I gave her 3 more weeks. And then on the other charge, failure to provide proof of completing community service, that's on the furnishing alcohol of a minor. She hadn't had her community service completed, so I adjourned that sentencing to today. Your name?
Probation.
All right, so I'm gonna listen to, and she, by the way, pled guilty to that as well, if I didn't say, to failure to complete community service. So what are we gonna do on this? What do you have to say, Mr. Drowsy? I mean,
Judge, that she's made tremendous progress. First of all, she has cleared the warrants in 25th District Court in Lincoln Park, also in 36th District Court. Secondly, she has completed community service, the 1.5 hours, and I believe she also did an additional 5.5 hours in the backpack giveaway through the Salvation Army in Monroe. Secondly, thirdly, she paid $138 for the classes, the impulse control classes, but she still does the money files in court costs, Judge.
so on 240, all I'm gonna do is sentence her on the probation violation. On the other case, that's 14118A. I revoked her 7771 status on March the 19th and entered the conviction. So I'm gonna sentence her anew on that one. Can I have another first page of a register? What do you have to say?
So Your Honor, I did receive proof this morning that Ms. Anna completed her community service. And she hasn't completed the Class A program yet. However, she did register for the next available one, which is in September. Besides that, the only thing I'm concerned with is she has not made any payments on any of her cases here.
How much can you tell me how much she owes on each one of these? Do you know or not? Amy, can you tell me how much she owes on 118A? That's on the case out of Rockwood.
$294.
Right. And let me just get my bearings here 1 second. And tell me how much she owes on 240.
240, she owes $485.
How are we gonna take care of that, ma'am?
Judge, she will be in a position to take care of it. First of all, she paid $138 recently for a program that she'll be taking, I believe, the 12th of September, the impulse control class. And then after that, while it won't be smooth sailing, she'll certainly be in a much better position to pay. Shows a step in the right direction, put probably in a position to pay $100. And if you have any money to pay today or within that's not.
And Judge, just so you are aware, you have another case with her on probation where she owes $309.
I'm sorry, what did you say 240 balance was?
240 is $485. 118A is $294. And then she has another case that is not scheduled for today, and she owes $309 on that.
Remind me her work situation.
Judge, what's been happening, she has been without transportation, but she is getting rides. Are you working at this time?
Where?
Culver's.
Culver's? What do you do there?
I'm in the kitchen, back of house.
I can let her do community service if she wants on the one case, but if you want to, but you got to start paying here otherwise. So she owes $485. Does she want to pay or does she want to do community service? But this has been going on since March of 26. And the other case that she's had here has been going on since May of 25. And I only fined her a grand total of $395 and she still owes $294.
Judge, how much community service would she have to do on that? That where she owes $485.
I mean, I can live with 35 hours.
Can you do that? Speak up, please. I can.
What other penalties do you think are required here? I'm asking you.
Really nothing else to add, Your Honor. She is signed up for the Class A program, so that will satisfy that requirement.
You know, if anything, I've been too kind to him is,
Judge, she's great for your time.
yeah, but you gotta get going here. How many prior technical violations this year they had? Can you tell me?
On the probation case, it would just be these current violations, no priors. On the non-probation case where the status was revoked, I believe she had one prior non-technical, and that was when her status was revoked.
All right, this is what I'll do. I'll keep you on probation, subject to all existing terms and conditions. You're to complete the Class A impulse control program. And so 35 hours of community service, I'll give you until October the 7th. Do not procrastinate. That's a lot of days. You understand? And then on the other file, I'm simply going to, remember, I've already entered the conviction and revoked the 771 status. I'm simply going to assess fines in the amount of $100 and costs in the amount of $200 for a total of $300 or 90 days jail. You understand?
Is that in addition to what she already owes?
No, no. So I'm really only adding $6.
Thank you, Judge.
And you're to pay, can you pay 50 per week on that one?
Get paid every 2 weeks.
You indicated you paid $50, one didn't pay $50.
You pay 50 now on that case. I'm talking on the 25R 514-118A. You pay $50 bi-weekly on that case beginning August the 31. I'm not putting her on probation on that. I want to be clear. And on the other case, you're to pay all your fines and costs by October the 15th. You think you can figure out a way to do that?
Pay everything by October 15th?
You're gonna have to pay the $485 that you owe on that case by October 15th, or else I have to extend probation. You want me to extend probation?
Judge,
Well, you can't have the best of both worlds. You're either gonna have to pay that by October 15th, or I'm gonna have to extend probation.
Judge, I believe did you indicate that she'd be in a position to do community service and moving the 485? Or
What am I thinking? Thank you. You're right. My apologies. Jeez. Thank you. Yeah, so you don't have to pay any fines and costs on that. That's what you're doing. You're doing your community service by October 7th. So you stay on $50 bi-weekly, do the Class A program, and you do the 35 hours community service by the date that I gave you, September the 30, or October the 7th, rather, and you'll be well on your way.
Thank you, Judge.
All right? If you need more time, come talk to me. Don't ignore me anymore. Okay, Ms. Anaya? You heard me, right? I've been too kind. Don't take advantage of this. Good luck. Thank you. People against Francisco Elijah's Cantu, 25F244-762A. All right, Mr. Williams, what is your client going to do? Can I have everybody's name, please?
D. Todd Williams, appearing on behalf of Francisco Dotson. Francisco Williams.
So is he going to acknowledge that he consumed alcohol on August the 9th and 15th, or what's he going to do?
This is what we're going to do, Judge. My client conferred with his schedule and his phone, and even texted his girlfriend. He's adamant that he did not drink the 9th or the 16th. However, Judge, on August 1st, when we were in the hallway discussing, he goes, Todd, honestly, I didn't drink last week, but I drank August 1st, texted with his girlfriend, confirmed it. He took his last sober link at 10 p.m. on August 1st. He and his girlfriend consumed alcohol on August 1st. He did not test positive in the morning on August 2nd.
August,
first. My client.
yeah, I know, but August 9th and 15th, you say you've got a positive blow, right?
Correct.
So we're gonna at least have a hearing on this, okay? So he can admit he consumed alcohol, he can deny it, it's fine that he's denying it. We're gonna have a hearing on those two, and I'm gonna make a determination as to whether or not he consumed alcohol on August the 9th and August the 15th. All right, that's what we're gonna do. Raise your right hand. You solemnly swear affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole true self you got.
Thank you.
Go ahead.
Two counts. My first count is on August 9th. There was a positive blow on the Soberlin device at 6 p.m. with the result of 0.046. The defendant then failed to comply with the retest blows as follows. These are all dated August 9th of 2026. He failed to retest at 6:15 p.m., 6:45 p.m., 7:15 p.m., 7:45 p.m., 8:15 p.m., and 8:45 p.m. My second count is on August 15th of 2026. The defendant submitted to a Soberlin blow positive at 6:25 p.m. with the result of 0.076. The defendant then failed to comply with the retest blows as followed. These again are all dated August 15th of 2026 at 6:40 p.m., 7:10 p.m., 7:40 p.m., 8:10 p.m., and 8:40 p.m., and lastly 9:10 p.m.
All right, do you have any questions, Al?
I do. Also, Donald, it's possible in your experience, an individual test and think they passed the test and walk away from the machine instead of going back and reloading, whether it
It could be possible. Every time they're instructed on the device, though, they are told to make sure the device is submitted. A lot of times when the device is positive, it'll show that it says retest in 30 minutes. So they're always, responded to make sure they take a look at the test to make sure it's submitted and that there's nothing.
So in other words, if an individual like Mr. Cantu gets comfortable, so to speak, with passing tests, goes in, blows, folds it up, closes it, and doesn't follow it, then it will go through the protocol showing that he failed to retest. So it is possible in certain circumstances that there could be an initial positive, waiting for the reaffirmation. But if the client doesn't follow the instructions, doesn't read the instructions, doesn't listen to the demonstration we fixed up, that they could, in other words, they lost the opportunity to prove that they hadn't drank alcohol.
It's definitely possible for him to do so.
So we don't have 100% confirmation that he drank alcohol. However, there was the VAC accepted by the machine, but because he didn't reaffirm that he retest, low number.
Correct. Those retests would have been able to confirm if it was an actual positive or if it was from an environmental factor, because those retests would have looked there.
But we are confident that he had those instructions, obviously, because there were several other tests where he did it right. I have one question as you look back in your notes. Did he ever have another instance where he did have a positive reading and then he did follow up with the reaffirmation, the retest?
No, he did not.
Thank you. I have nothing else, Judge.
Does he wish to testify?
No, Your Honor, my client can accept.
Any argument? Either one of you.
Judge, other than obviously we had a positive test, it's unfortunate that he didn't get back on and retest. Other than that, I hope you take into account that my client did admit to consuming alcohol against your orders on August 1st.
All right, the court finds the defendant did in fact consume alcohol on August the 9th, that he tested at 0.046 and then failed to submit to the retest, and furthermore, that he tested positive on August 15th for alcohol and then did in fact consume alcohol, and he had a 0.076 reading and then failed to submit to retest. So this is where we are. I want you to remind me, on the drunk driving that was adjudicated, that was in Standish, correct?
Correct, Judge.
How many days did the judge give him there?
Judge, it was 24 days he gave him, and I believe he did 19 days.
Anything you'd like to say before I sentence him on this?
Process closure, if you want to tell the judge.
Definitely, not proud of my decisions. so far, but I definitely feel after everything's said and done that I will learn my lesson. And yeah, yes.
Did you ever talk to your probation officer about the fact that you didn't have insurance to get an IOP?
I did mention it one time.
We did, we talked about the 1-800 number. He was going through, I believe it was Sacred Heart, and Sacred Heart will take you if you don't have insurance.
Right.
You go through, the questions and everything like that. I'm not sure if he went through all of that with them, but I know he was in contact with Sacred Heart last time I know.
Did you?
I contacted them and they said that they didn't have a ILP in their area. So they they gave me a recommendation number, and then that person ended up giving me multiple different numbers that I called, and some of them were a bit expensive, like $200, $300 a day, 3 times a week. And I can't afford that out of pocket.
Anything else, Mr. Williams?
So other than he completed not only his community service for here in Standish, and that was the last hurdle that he had for Standish. Paid his money in full, and
He's paid all ours.
correct. He has, as well as other more.
Judge, I would like to add this for us, he has 4 days credit jail. For 1 day that he served while he was in custody when he was arrested, he did 2 days on the court work program, and then he completed 1 day of community service for us.
You know, your lawyer gave a very spirited argument when he was here before. And he did a really good job for you, but he can't save you from you. There's no doubt in my mind you were drinking after we had that hearing, whether it was on August 1 and certainly, I believe, and found on August the 9th and 15th. And after you went through 2 drunk drivings, I would have thought you'd stop that. I get the fact you had an addiction problem, but you made up your mind for whatever reason you couldn't go to IOP, and then you still kept drinking. And the reason I wanted you in IOP is I wanted to help you. And frankly, I'm not sure I would have done what I'm doing today had you followed the rules and been abstinent from alcohol and drugs. I'm sorry, probation's revoked. You're to serve 45 days, credit 4 for 41. I won't assess any costs. You've already paid that. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer. Thank you, Mr. Williams. Have a good
Thank you,
day.
Judge. Thanks for the side consideration.
Have a good day. Nice to see you. Haley Clark, I'm sorry. Haley Kathleen Clark, 26W843-638. All right, ma'am. How are you? Your name? You're going to plead to impeding, right? Yes? Yes?
Yes.
Okay, responsible or not responsible to that? I'll accept your plea. 150. I'll accept your plea. 150 and the original charge is dismissed. Okay, just keep your voice up for me. How much time do you need?
Huh?
How much time do you need?
Just a week.
I'll give you until August the 24th. If you don't have it next Monday, call the court. We'll go on Zoom. I'll give you an extension. Okay? Have a good day.
Alrighty, friends, hour 3 of TCF Live. Let's go back to Texas, check back in with Judge West.
Good morning, you're Don Charles Scott.
Yes, ma'am.
And this is 25 DCCR 0504. It's my understanding Mr. Johnson is going to be requesting pretrial diversion. And there's been just a few issues that has prevented him from doing that. What I'm gonna do, Mr. Smith, is just reset it one more time. If you'll get that request in quickly, that way they can take a look at it before that next court date. We'll have an answer.
I was able to take care of that.
Okay, perfect.
Thank you.
Stay in touch with Mr. Johnson, so that if you are accepted, there's going to be a signing date and things like that. We might have to have another court date before that. So just make sure you stay in touch with his office. They'll let you know what's going on and when to be back.
Yes, ma'am.
Okay, you're free to go. Tyron Williams, it's a sentencing.
regardless, this one, Williams has a mandatory 10 days. Mr. Williams is gainfully employed. Will allow him to serve them.
Yeah, we'll talk about that in just a second, but typically I will.
Thank you, Judge.
All right, sir, you're Tyron Williams. And this is 24 DCCR 2242. Mr. Williams was previously in court, entered a plea of guilty to driving while intoxicated, third or more. I've received that pre-sentence report. Have you both had an opportunity to review that?
Yes, ma'am.
Yes, sir.
Any additions or corrections?
No, ma'am.
And Mr. Williams, where are you working right now?
So for performance, contractors incorporated.
And do you work a normal week,
Yes.
Monday through Friday?
Yes.
And so, Mr. Smith, any objection to me allowing him to serve those 10 days on the weekends?
I do.
So what I'm going to do, Mr. Williams, is find that you previously entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time, find you guilty of driving while intoxicated, third or more. Sentence you in accordance with your agreement to a term of 10 years in prison, but I'm going to probate that. You'll be on probation for 8 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. You're also ordered to serve that mandatory 10 days upfront time. I'm going to allow you to serve that on weekends starting this coming weekend. So you'll be ordered to report to the Jefferson County Correctional Facility this Friday, the 21st of August. You need to be there at 6 o'clock. Don't be late. Don't show up intoxicated. Some people think they're going to show up, and kind of sleep it off over the weekend. Don't do that. And you'll go each weekend until you serve those 10 days. Okay. Also, I am ordering that you enter and successfully complete the Jefferson County Drug Intervention Program. That is an outpatient program. It's intended to help you make sure you stay clean, sober, and safe. All right. Probation will talk to you about all of that.
Okay.
If you do everything you're supposed to on this probation, then for all practical purposes, your case here in court is over. You'll be able to serve that 10-year sentence while you're out on probation.
Yes, ma'am.
The other side of that, though, is if you violate any condition of probation, you'll be back in here and looking at that 10-year sentence you've already agreed to.
I want to.
No, I'm sure you don't. I hope not. I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. I'm required to read this to you. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Johnson. If you'll just have a seat here in the courtroom, probation will call you up to her desk when she's ready to go over your paperwork. All right. Good luck to you, sir. Thank you, Mr. Johnson.
Thank you.
Take care.
Yes, ma'am.
Mr. Pageant, you've got a sentencing on Darius Jack. Good morning. Are you Darius Jack?
Yes, ma'am.
And this is 25 DCCR 1624. Mr. Jack was previously in court, entered a plea of guilty to violating a protective order 2 or more times, and I have received the pre-sentence report. If you both had an opportunity to review that report.
Yes, Your Honor, I have.
Any additions or corrections?
None, Your Honor. Nothing from the state judge.
All right, then, Mr. Jack, at this time, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, but I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 5 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. That includes obviously having no contact with the victim in the case. And I understand that you guys have a child together. So it's very important that you get with Mr. Pageant or someone to make sure that you have some legal documents in place for visitation and things like that. I will allow you to have contact or communication with her only through what's called the Family Wizard. It's an app that y'all can get on your phone. I will require you to pay the cost of that app for you and her. That's how you will communicate about your child, unless y'all have a family member or someone else that you can go through. The good thing about that app, though, it's really designed to protect both of you, not just her, but you too, because everything you do is saved on that app. So she can't say, well, he said this or he did that. If you send a message that says the kid has a doctor's appointment or soccer or whatever it is, it's there, can't be deleted, can't be changed. So it's really a good protection for both of you to use. You can talk to Mr. Paget more about that.
May I speak?
Sure.
Go ahead.
I have this ankle monitor on. Is there any way I can get this off? I've been on it for about 7 months.
So that was a condition of your bond, and I don't know, do you have any issues?
I don't see anything
That's happened since then?
that would indicate. He has been very diligent with it, and I don't think there are any violations, but it's been a great financial burden on him, and he's with one which he's managed to get done.
What's the status of the Hardin County?
We have court on the 20th, and I've spoke to the prosecutor there, and we're going to be running something concurrent with your case here, Your Honor.
Give me just a second.
Absolutely.
They also, there's another, it's called a Talking Parents co-parenting app. I don't care which app you use. If there's a new, better one, it's been a long time since I've used Family Wizard, but it will be through an online application, some type of app on your phone that y'all have communication about your child. You'll also be required to follow any and all rules if you get a probation in Hardin County with regard to contacting communication. Do you understand? Are you required out of Hardin County on that bond? Have they required you to have that GPS monitoring device?
No, Your
No,
Honor.
it's
They
just
have not.
here. Okay, so it was a condition of your bond here. It's not a condition of your probation. So as of today, you'll be able to get that taken off. So here's the thing, if you have any communication or contact that you're not supposed to have, not only will you be in trouble here, you're going to be in trouble over there. You're looking here at going to prison for between 2 years and up to 10 years, just for having the wrong kind of communication. It's that simple. So she cannot give you permission to violate this order. So she may say, you know what, it's been a while, everything's fine, let's meet, let's do whatever, let's talk. You can't do it. Only I can give you permission to have any other communication other than about your child, other than through an app.
Yes.
Makes sense? If you do everything you're supposed to, get past the situation and successfully complete your probation, this is an excellent opportunity because you do not have a felony conviction on your record. And at the end of the probation, the case will actually be dismissed. You'll never have a felony conviction. But the other side of that is if you violate any condition, you'll be back in here again and looking at going to prison for 2 to 10 years. Do you understand?
Yes.
I'm handing you the trial court certification and it shows this was an agreement that I followed. And so you've waived any right to appeal. You'll just have a seat here in the courtroom. Probation will call you up to her desk when she's ready to go over your paperwork. All right. Good luck to you, sir. Thank you.
Thank you, Your Honor.
Thank you. Thank you. Mr. Paget, you have another sentencing on a Daniel Martinez. Good morning. Are you Daniel Martinez?
Yes.
And this is 25 DCCR 1414. Mr. Martinez was previously in court, entered a plea of guilty to aggravated assault with a deadly weapon. I received the pre-sentence report and has everyone had an opportunity to review the report?
Yes, Your Honor. Yes, Judge.
Any additions or corrections?
None.
Explanations about self-defense?
There are situations that he'll tell you about, Your Honor, that he asked to speak about.
So here's the thing, Mr. Martinez, in your pre-sentence report, you didn't really accept responsibility. You said that you did this, but that you did it only in self-defense. If you did something in self-defense only, then
Listen to her first.
then obviously that's a defense and you should go to trial.
Yes.
But if you did it and you're taking responsibility, then I need to know that.
No, about that responsibility. I said that to the probation officer.
Okay.
He probably took it a little bit wrong.
Okay, all right.
Yes.
Any reason not to go forward then with sentencing, Mr. Smith? All right, then at this time, Mr. Martinez, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney's office, defer all proceedings, place you on probation for 6 years. You're ordered to pay the $1,000 fine and to follow all the rules and conditions of probation. One of those is going to be that you are not allowed to have any drug or alcohol. And I am, at least for some amount of time, going to order that you wear a scram unit, which is a unit that will tell me immediately if you have any alcohol in your system. Probation can tell you where you need to get that, but you need to get it, give them proof of it. Mr. Paget can explain that as well. Everything in here looks like alcohol had a huge part of it. The substance abuse evaluation that they did tells me that alcohol is an issue. If there is anything else that probation feels like would be helpful to make sure that you stay clean and some type of program, then you're going to be ordered to do whatever it is. Do you understand? If you do everything you're supposed to on this probation, this is an excellent opportunity because you do not have a felony conviction on your record. The end of the probation period, if you're successful, the case will actually be dismissed. You'll never have a felony conviction on your record. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, so you would be a convicted felon, and you could go to prison for anywhere in the range of punishment, which is between 2 years and up to 20 years in prison. Do you understand? Yes. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. And if you'll just have a seat here in the courtroom, probation's going to call you up to her desk when she's ready to go over your paperwork. Yes, sir?
Yes, ma'am. I have a screen device. I've been wearing it for 10 months.
Okay.
I have a GPS monitor that I've been wearing for 10 months.
So the GPS was a part of your bond. That's going to be, that's off. You can get that off today. The scram until, if you'll just make a note that if they feel like that's the length of time is enough on probation, then they'll send me something over. But for now, let's keep that on. I know it's a lot of money. You can take the GPS though. You're done with that because that hadn't had any issues. And as long as they double check on that scram, then I'm okay with that as well. Just
And Your Honor, if he does his submission, if he shows that he's staying clean, no violations on it.
No, they'll take a look at how long you've had it on once you get with your probation officer, and it shouldn't be much longer. They'll send me something. We can get that.
Thank you very much.
Okay. Thank you, sir.
Yeah, this is explaining this to you.
Alrighty, friends, final half hour now of TCF Live. Let's go across the hallway, check back in with Judge Stevens.
My translator from the office.
Yeah, okay. And this state is present and the defendant, his attorney, and a translator is present. Okay, introduce the lady who's going to be translating in this case, please.
This
is Moscardo.
All right, we're going to need a spelling so that the court reporter can get everything.
MOSCARE. No, nothing.
All right. And you are here to translate in this case, correct, ma'am?
Yes, Your Honor.
Okay. Have you translated in courts before?
Yes, Your Honor.
And you're translating English to Mandarin and Mandarin into English. Now, the defendant understands Mandarin and is not fluent in English. Okay. And so what we'll do is swear you in. Do you solemnly swear or affirm that you will truly and accurately translate in this hearing Spanish? I got caught. We are 98% of what we do is Spanish.
Yes.
Mandarin to English and English to Mandarin. Mandarin being the language the defendant understands, English that what we will transcribe into so we can all understand and the record will show. Will you do that translation accurately? So help you God.
Yes, Your Honor.
Lower your hand. Now, please tell him what we'll do is I will be asking him questions directly. And he must answer them. And I'm going to swear him in. Raise your right hand. Do you solemnly swear or affirm that you will make true answers to all questions asked of you during this hearing? And you will do that correctly, so help you God. All right, lower your hand. Thank you. And what I'll do is I'll ask him in English and then we'll wait for, he'll speak to you and then you will pass on the translation from Mandarin into English so we can all understand and the court reporter can take this down. Are you Xingshang Yang?
Yes.
Okay. You are charged here in 25 CR 1342. With the third degree felony of theft, which if convicted, you are facing no less than 2 nor more than 10 years confinement in prison. And a fine up to $10,000 can also be assessed. The indictment states that on or about August 19th, 2025, in Jefferson County, Texas, you committed the offense of theft involving money of a value of $30,000 or more, but less than $150,000. Do you understand fully what you're charged with?
Yes.
Yes. All right. Your attorney has filed a motion to withdraw. Mr. Zarate has been your lawyer, correct?
Yes.
He has filed a motion to withdraw as your lawyer.
那像法院提到的一份动议，说明他有抽中你的代理。Yes.
You've spoken to him about this?
Through my translator, yes.
Okay. And is it your understanding you've spoken through the translator to with your attorney, and your attorney is asking to withdraw and you're going to have to get another lawyer to replace him? Do you understand?
所以你明白你跟你的律师还有翻译聊过这个抽出代理的这个状态，所以说你要知道，不能不说让你要另外再请一个新的律师了吧？是 ，yes.
All right. If I grant this motion, are you able to hire a lawyer financially?
如果我同意了这个抽出代理的动议，你在金钱上面会负担得起新的律师的吗 ？Yes.
Are you employed?
你现在工作吗？
What do you do?
你做什么？She's in the kitchen. Okay.
Kitchen chef.
Okay. How much do you, what's your salary?
你这个工资是多少？Do you ask me before tax or after tax?
Gross, before.
在税前，5,800.
5,800 per month?
Yes.
Or week?
是一个月还是一个月？A month.
Okay. If it was a week, I was going to change jobs.
Yeah.
Okay, so that ends up being $70,000 plus over a year.
所以你的年薪大概7万块钱以上是吧？差不多。
72.
Yes, sure.
That's 6,000. All right. So how long would it take you to hire another lawyer if I grant this motion to have your lawyer withdraw? How long would it take?
如果今天我同意了这个抽出代理的动议的话，那你觉得你大概多长时间可以遇到新的律师？ I already hired an attorney.
Ma'am?
I already hired an attorney.
Oh, you've already hired somebody. What is the lawyer's name? Oh, that's you?
That's me, sir.
Come on up. Let's get everybody in on this. Again, I think we can do more damage as a group.
Right.
Okay. And you speak English?
I speak
right?
English.
Okay.
English.
Would you, and you're an attorney at law here in Texas?
Yes, sir.
Okay. Please state your name for the record.
My name is Daryl, Daryl. Last name is Ward, Ward. My bar number is 241-3099.
And where's your office, sir?
It's going to be in Houston, Texas.
Okay. Welcome
Thanks.
to this court. Thank you. Yeah. We're gonna have you to fill this out here in a little bit, so before you leave, if you'd be so kind. And you've spoken with Mr. Yang. It looks like an agreement has been reached between you and Mr. Yang, and you will be taking over his legal representation if I grant this motion.
That is correct, Your Honor.
All right. Does everybody believe that's what's in the best interest of justice here under these circumstances?
Yes.
From both lawyers here. All right. Then I'm going to allow Mr. Zarate to be released.
Thank you.
And then I'm going to allow the new attorney to be placed as representation here immediately or forthcoming when you can get that filled out. And we will get all your information with our coordinator, and then you will be in the game. And what we're going to do is this is a case that was it's a year old almost. So I'm going to give you some time to get with your client and get an announcement docket done. How much time do you think you would need to make that announcement? And then that's what we normally do is before we set it for trial or other disposition, or if y'all can work a disposition out in lieu of that, let me know, because we're always welcome to dispose of it. But how much time do you think?
It's 4 weeks.
You got it.
Okay.
Yes, sir.
Just to be clear, I don't think he heard earlier when the state stated that they messed up the phone dump, so they're trying to get new copies. So I don't know if that changes with the time. I missed that one. Yeah.
Well, what I want is 4 weeks. We're going to have either an announcement or a meeting to determine what the status is, to make sure that discovery is complete. You've got it in your hands and you've got enough time to make a intelligent decision and work with him. Okay. Yes, sir. Anything else we need to do today?
Nothing further.
All right. So you're released and you're in the game, and welcome to Jefferson County, and we welcome your professionalism, sir. Thank you. All right. This is reset. Please get a resetting. 4 weeks. Thank you.
Alrighty, friends. Specs, thank you for the $5 super chat. Thanks, good morning, and hi, and I appreciate you. Well, we appreciate you too. It's good having you here, so thank you very much. Let's go across the hall. Judge West.
And this is 25 DCCR 0882. Ms. Berry is set for trial for next Monday to begin with jury selection. And what is the announcement?
We're ready, Judge. I think Stacy's ready, Judge.
Okay. Any changes in any type of negotiations or that we need to talk about?
No, ma'am.
Looks like there was a rejection done a few months ago that was for a 10-year term in prison. That's still the offer?
Yes, sir.
All right, then, Ms. Berry, I'm going to number the cases for trial tomorrow after the docket. So stay in touch with Mr. Radford. He'll know tomorrow what the trial order is, but I anticipate seeing you back next Monday at 1 o'clock, okay? All right, you're free to go. We reset Locker Fury. It's kind of bumped through.
I know, okay, bye.
Oh, I see. Mr. Smith, what's the status of the federal Locker Fury stuff? Still waiting?
Thought about that. I emailed Ray, still haven't heard back. No change. The last time I talked to him, he said that the FBI is taking it from him and what they're supposed to be doing.
Ms. Lockhart Fury, I'm going to reset your case one more time. Stay in touch with Mr. Rennick. We'll let him know if y'all want to send him a message. And make a note for me. I'm going to get with Ray again on that. Moran. I'll see if I can find something out.
Scott said it. He's going to be here.
Yeah, but if we're just resetting it, yes, ma'am.
Lindsay, thank you for gifting 5 memberships. I very much appreciate that.
Thank you, Cal. Mr. Reynolds, you've got John Taylor. Mr. Smith on John Taylor. Good morning, sir. Are you John Taylor?
Yes, ma'am.
And this is cause number 25, DCCR 1427. And it looks like Mr. Reynolds has filed a motion to withdraw as attorney. Is that correct?
Yes, ma'am. And I've gone over that with him.
All right. Do you have any objection to that, sir?
No, ma'am.
So I'll grant that motion. And Mr. Taylor, are you able to hire another attorney?
Yes, ma'am.
So what I'll do, Mr. Taylor, is reset your case for about 30 days, and we're going to put you back on that designation docket. If you get a lawyer hired, I'm going to get you to sign a reset today so that you can bring that to that lawyer. If you are unable to hire someone before the next court date, make sure you talk to at least 3 attorneys. Bring me those names so I know you're trying, and we'll discuss your options, okay?
Yes, ma'am.
All right, if you'll step in front of the clerk, she'll give you that reset notice. Mr. Eckhart, you've got Bobby Clark. Hmm. Morning, Ms. French. Morning. Good morning, sir. You're Bobby Clark. And this is clause number 25, DCCR 0802. Mr. Clark is set for trial to begin with jury selection next Monday. And what is the announcement?
So Judge, we can be ready if we're put in the order. However, I think you know that I've spent most of my last month working on that case with Philip that was supposed to be on this docket. It was originally on this docket. So I haven't really done a lot of preparation on this case, but we can be ready if we're put in the order.
Okay.
And then also I'm tentatively not available on Thursday and Friday next week.
Okay.
I have to, I'll cancel.
Okay. Ms. French.
Well, the state relied on Mr. Eckert's.
I did. So about a month ago, I did tell Judge that we were getting ready on this capital case and that I wasn't planning on trying this case.
Because it's so new as well.
Here's the thing, y'all don't get to pick which cases get numbered first or second. And I understand that capital was obviously a big one, but when we've got a child case, it takes precedence anyway. So that's you guys relying on each other. You should not do that. You should rely on me for that. I'll take that into consideration when I'm numbering the cases, but in future, make sure you loop me into that and don't assume that certain things are going to happen with the trial docket. Okay. Stay in touch with Mr. Eckhart. He'll know tomorrow by noon or a little after that what the trial order is for next week. And he'll let you know when you need to be back next week. Okay. All right.
Alrighty, friends, back across the hall, Judge Stevens.
He speaks no English. Well, most of the attorneys don't.
Swear him in.
You write about the gibberish. It's farm gibberish that I've gotten used to.
So you're used to it.
We learned that in law school.
But yeah, he kind of helped me out, huh?
We're getting better.
We're getting much better.
On Mr.
It's going to be 1
I've
year.
got 2 cases here. Is he leading to one?
The both of them, 1 year state jail, and he's currently serving time in TDCJ. So I went to his TDCJ case. I think he has
Yes.
If I'm not mistaken, I believe he has 20 years.
Okay, I see both of them are.
Sure.
You see that on the TDCJ case? I think he said he got about 20 years. I'm not worried about that.
All right, we call two cases, 21-38689 and 22-39235. The state of Texas versus Jorge Ramirez, or is it Ortega? Ortega? Ortega?
Orteaga.
Orteaga.
Yes.
Orteaga. See. All right, and that's usted, you. All right. You, Mr. Orteaga, speak English, see, or no? Okay. Do you speak Espanol?
Sí.
Ah, that's you're fluent in Spanish.
Sí.
See, all right. This lady is going to be representing you, and she will help you speak and translate from Spanish to English. And please tell us, introduce yourself for the record, ma'am, and tell us your history and knowledge of Spanish and English. So we know you're an expert. Yeah, go ahead. Raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Judge.
Lower your hand. Go ahead.
Hey, my name is Jennifer Araji. I do translate English to Spanish and Spanish to English in the misdemeanor courts. And I have a few time in the felony courts.
You've been here before in this
Yes,
court,
sir.
and
Twice.
you've translated in other cases as well.
Yes, sir.
And do you solemnly swear or affirm that you will truly and accurately translate from Spanish, the language that the defendant speaks, to English, so all of us in the court reporter can understand and the record shall be accurate of what is being said, and then you will translate from English to Spanish so that the defendant can understand? Will you do that accurately, so help you God?
Yes, sir.
As you've done in the past in other cases?
Yes, sir.
You or Jorge Ramirez Orteaga?
It's Jorge Ramirez Orteaga. Yes.
All right. Does the defendant waive formal readings of the indictments and the arraignments in each of these two cases, 21-38689 and 22-39235? Can we proceed in summary?
Yes, sir.
In summary, 21-38689, that indictment states that on or about September 17th, 2021, in Jefferson County, Texas, you, Jorge Orteaga, committed the state jail felony of debit or credit card abuse. That you used a debit card, namely a Nature's Credit Union debit card, and you knew that that card was not yours. And it was not used, and you used it though without the consent of the lawful card holder. Do you understand what you're charged with here?
Yes, Judge.
This is a state jail felony, which means if convicted, you face confinement in a state jail for any term of not less than 180 days nor more than 2 years in the state jail. And you can be assessed a fine up to $10,000. Do you understand what you're charged with and the punishment range applicable?
Yes, Judge.
Agreement has been reached where you would be pleading guilty, sentenced to 1 year in the state jail to run concurrently at the same time with 22-39235, the other case. Is that your understanding of the agreement?
Yes, Judge.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
No puedes apelar el caso después. Yes, Judge.
Was there any loss here?
It was $100 on one, $250 on the other. But since he's doing time on another case, he's not gonna be able to pay it.
First transaction was 75 and the second transaction was 75.69.
Yeah, one's files number 38689. There was $150, and then the other one was $270.63. Since he's going to prison on the other case, there's no collecting it. So,
I don't know what he has, if anything, but are you able to pay this loss back, which was, what'd you say was? Ronnie knows what I think about the victims. I'm sensitive to that.
$150 on
100. Okay, you victimized one victim for $150, and then a second victim, and the second victim loss was. You said the second one was? There was 150 on one.
Second one was $270.63.
$270.63, which is $420.63 total loss. Are you able to pay that back? Do you have the money to pay $400 to these victims?
Está preguntando si tienes el dinero para pagar a esas víctimas exactamente. Yo no tengo dinero bastante porque si me ponen pago, yo no tengo pago. Okay, so he says he doesn't have the money in total, but if you can put it in payments, he can pay it back.
How's he going to do that in jail?
¿Cómo lo vas a hacer eso cuando estás en la cárcel? His mother. He said that's the only person he has.
How long would it? How long would it be before she can pay this loss back? When can she do that?
Para pagar todo. Yeah. ¿En cuánto tiempo? 6 months.
6?
Yes, sir. He says also, if you tell him otherwise, that he'll tell his mom and they'll make sure to get it paid.
Can she do it in 1 week?
The total.
Sí.
Está preguntando que si ella puede pagar todo completo en una semana. He said, if you can give him 2.
Okay, see, because he was looking at up to 4 years in both of these cases.
Dice que con el tiempo iba a ser 4 años.
This agreement has been placed to 1 year in both cases to run concurrently, so he is getting a great deal, but these victims have to have their money back before I take this deal.
Okay, dice que antes de aceptar lo que están pidiendo el Estado, usted tiene que pagar todo eso multa completo para atrás a la víctima.
If it's repaid in 2 weeks, I will accept this arrangement.
Dice que si puedes pagar eso, la multa en 2 semanas, le va a aceptar lo que están pidiendo de la money para los 2 casos.
All right, what I'm going to do is hold this in abeyance. We'll reset it in 2 weeks. come back, and if it's paid, then I will accept this agreement. All right? This also help on this one. How does she get the money to pay the people back? How does she get the money? Mr. Laird, what's the way to do it?
Bring it up to our office, money orders for each amount.
She needs to have a money order in each amount, bring it to the DA's office. And one is 100 and, well, here it is, right here, in each amount. Not the total, but two separate money orders. And it goes to the district attorney's office. And she needs to tell them what case it is, his name. And that was to pay restitution. Mr. Laird, do they need any other information? If it's just the defendant's name, is that?
We can make sure we get it right.
¿Cómo se llama? El abogado está son una oficina aquí, pero en el tercero con su qué. Sí, pero separado, ¿sí? Entiende que tiene que ser uno de puntos de igual.
This is very important because he's looking at together 4 years total, but this agreement is 1 year together. So it's all conditioned on the victims getting their money paid back in 2 weeks. It's in his best interest.
Okay, he said that he'll make sure that it gets paid.
Good. And where we said 2 weeks.
2 weeks.
Thank you. Muchas gracias. I'll still wait. Thank you.
Okay, todo eso es tuyo. Nomás que hables con ella. O el día. Okay. Okay.
All right. Raymond Johnson, Mr. Jeff?
Yes.
Lindsay, thank you for $10 for TCF overtime. And yeah, we're going to do some overtime. I'm going to go to the bottom of the hour, so we'll add an extra 30 minutes today, making up for last week when we had a short show because of technical issues. So let's continue with Judge.
Yeah, I'd like for him to know that the offer that's being made today will only go up if he sets for.
Any drainage?
He's a habitual, and he's currently turning down 10 years.
Really? Math isn't working out there.
No, it does not work to his favor.
All right. But that's how we. This room is filled with bad choices.
Yes, sir.
All right, we call 25 CR 1667. Are you Raymond Johnson, also known as Raymond Johnson Jr.?
Yes, sir.
And you're here with Mr. Jeffries, your attorney, and the prosecutor. You are charged here with a third-degree felony of evading arrest or detention with a motor vehicle, which would carry with it, if that was all there was, no less than 2, no more than 10 years confinement in prison, and a fine up to $10,000 would be assessed. But I'm looking at the indictment. Paragraph 2 states you have a forgery, third-degree felony forgery conviction in 2019 out of the court next door, the 252nd District Court of Jefferson County, Texas. After that conviction became final, paragraph 3 of the indictment states you committed the felony of unlawful possession of a firearm by a felon, a third-degree felony, and you were convicted of that on March 20th, 23 in this court, criminal district court. But it doesn't end there. After that case was final. Nope. You were convicted twice in this court. Yes, okay. On the same day, March 20th, 2023, of 2 separate unlawful possessions of a firearm by a felon. So paragraphs 1, 2, and 3, 4 together constitute, if found guilty, you're looking at habitual felon status, no less than 25 years to life imprisonment. All right, that's as serious as it gets. Do you understand what you're looking at here?
Yes, sir.
All right. Where are we?
We'd like to put it on trial.
Okay, all right.
I wanted to state on the record, Judge, that today he's been offered 10 years, which is substantially lower than the habitual deal. Any delay is going to result in that offer going up. So I appreciate
an aggravated case, right? He would be eligible for parole in a quarter of the time, 2.5 years if it was 10 years. So you can do the math. You've heard this, you've talked to your attorney, you're making this decision freely and voluntarily to pass on that deal, and you're going to roll the dice on a minimum 25 to life. Is that what you're going to do?
Yes.
You've thought about it? All right. Then is that your final answer? Yes.
Yes, sir.
No deal. No deals. Let's put it on the trial docket soon. And that, I won't accept any offer other than what the jury does. We'll let the jury decide your fate. That's the way it works. Jay Nelson, James Macon.
You just saw track responsibility.
Okay.
That's what make a lot.
James Macon. No, and a lot of. Hey, Reagan, Patrick Thomas. Not here. Matthew Farrell, Brent, Dedrick, Davis.
Davis?
Oh, we do one. We can do. So. On Dedrick, Dietrich.
Cool.
Okay.
What'd you do, Brent, this weekend?
No,
You work?
I was in the office.
Oh.
Davis? Come here, please.
I used to New York.
Raise your right hand.
Got in the way, so I just hired somebody to do it.
Truth and the truth of you got? Yeah.
that last one didn't make any sense. It's on video where when he's pulled over, he admits to it. And
I don't know. What do you do? It's just some people become examples for others. Sometimes it's a good example. Sometimes it's a bad example. Okay, you're Mr. Dietrich Davis, and you're here with Mr. Turk, your attorney, and the state's attorney. What's our plan? We've got two cases here. 26 CR 828, theft of property, and
We have an agreement of 2 years state jail on the state jail offense with 2 years TDC on the other to run concurrent, Judge.
and then you got obstruction. The other one is obstruction, which is a 3rd-degree felony.
Correct, Judge.
All right. And you are Dietrich
Yes, sir.
Davis, and Mr. Turk is here. Does the defendant waive formal readings of the indictment and the arraignments here? Can we proceed in summary?
Yes, Judge.
26 CR 828 first. In summary, this indictment alleges that on or about March 13th, 2026 in Jefferson County, Texas, you committed the offense of theft, and even it was involving food of a value of less than $2,500. But paragraph 2 goes on to allege that you have 2 or more prior convictions of thefts. 1, 2, 3, 4, 5 convictions out of county court at law 2 of Jefferson County, Texas, and out of the 252nd District Court of Jefferson County, Texas. 3 of those are misdemeanors, 2 are felonies. Paragraphs 1 and 2 will constitute a state jail felony, which means you are looking at no less than 180 days up to 2 years in the state jail. And a fine up to $10,000 can be assessed. Do you understand what you're looking at, sir?
Yes, sir.
All right. In this case, an agreement's been reached where you would be pleading guilty, sentenced to 2 years in the state jail. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
What's our plan in the other case?
2 years, Tennessee, 2.
Are those going to be running concurrent?
Yes, sir.
That's not shown here in the,
It is the agreement, Judge.
okay, I'll put that in. All right, once again, if I follow this agreement, you have no right of appeal of your case. Do you understand? Also, the 2 years will run concurrently with the other case. Okay. If I follow this agreement, so you have no right of appeal of this case. How do you plead to this? Guilty or not guilty?
Guilty.
Sir?
I plead guilty, sir.
Are you pleading guilty voluntarily and because you are guilty?
Because I'm guilty, this is voluntary.
And voluntarily. Nobody's forcing you to do this. You're doing it on your own free will.
Yes, sir.
Okay.
Yeah. She's gonna be here. Always gonna be here.
Yeah, I'm gonna put that one aside for just a moment and go to the second case.
Yes, but anything wrong with it? Over here, come on.
In this 26 CR 959, this second case alleges that on or about April 30th, 2026, in Jefferson County, Texas, you committed the third-degree felony of obstruction or retaliation. Essentially, it states you intentionally or knowingly threaten to harm another person with assault in retaliation or in account of the service of that person who had reported a crime. I guess it must have been the theft case. No, it was something else altogether. All right. Do you understand what you're charged with, though?
Yes, sir.
This is a third-degree felony. If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed that would exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached in your case where you would be pleading guilty, sentenced to 2 years in prison, and this is going to run concurrently.
Yes, sir.
With 26. Let's see. 828. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this case? 26 CRA 26 CR 959, the third degree felony of obstruction or retaliation. Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir. Nothing wrong, sir.
And because you are guilty?
Yeah.
Okay, yes.
Yes, sir.
Yes, but yeah, I'm going to show you what's marked as State's Exhibit 1 for both cases. Did you sign those documents? Understand it? Discuss it with your attorney. Are the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered in evidence without objection is made. In each of these cases, State's Exhibit 1 states that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read them. You are guilty of the crimes charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true. It states so help you God.
Yes, sir.
Okay. State's Exhibit 1. In each case, made a part of the record for all purposes. Pre-sentence reports are waived?
Yes, Judge.
All right. Mr. Davis, I'm going to follow these agreements. I'm going to find in each of these two cases you have pleaded guilty to. You have entered your guilty pleas voluntarily, knowingly, intelligently. There was sufficient evidence supporting your guilty pleas from State's Exhibit 1 in each of these cases where you waived your rights to appeal and waived your rights to a jury trial to enter your pleas of guilty. State's Exhibit 1 and your plea of guilty and your sworn statements stipulating that you are guilty in each of these cases. That is enough to to find you guilty beyond a reasonable doubt in each of these two cases. I now find you guilty in 26 CR 828, the state jail felony of theft. You were hereby sentenced to confinement in the state jail for a term of 2 years. And in 26 CR 959, the third-degree felony obstruction or retaliation, I find you guilty of that third-degree felony. You were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 2 years in that case. These sentences shall run concurrently. Do you understand what's happening?
Yes, sir.
All right, good luck to you. Yes, sir. Do better. You can do it.
All right, Jefferson County seems to be where it's at for us here, the last part of the show. Let's go across the hall then, back to Judge West.
Broderick Kelly. Good morning, sir. You Broderick Kelly?
Roger Guillory.
Guillory, I'm sorry.
That's what I.
I don't know why I was saying Kelly, I guess because I just called Mr. Kelly's case. You're Broderick Guillory. Sorry, Ms. Malfino. No wonder you couldn't find that file. It's a sentencing. Yes, ma'am. That's because you know how to read my mind. Everybody else doesn't apparently. All right, Mr. Guillory was previously in court in cause number 25 DCCR 1716, entered a plea of guilty to the state jail felony offense of burglary of a building. I've received that pre-sentence report. Have you both had an opportunity to review the report?
I have, Judge. There is something that we definitely want to address, and I've spoken with Mr. Guillory about it. He would like to address it for Judge to.
Okay. Go ahead.
Yeah, I was, in the paperwork, I was a little nervous talking to the,
Speak up.
I was a little nervous talking to the woman about probation.
Yep.
And I basically wanted to say that I did what I was doing.
Okay, so it gives me concern, Mr. Guillory, that you come in, plead guilty, and then you go say, well, I didn't really do it. Somebody else did it. Accepting responsibility is sometimes hard, but it's something that you do, especially as an adult and when you've done something like this. So if you didn't do this, someone else took your truck, did all those things, then we'll have a jury come in and they can decide. If you did it, then just accept the responsibility because things will go a whole lot more smoothly between now and the end of this probation, hopefully. Does that make sense? Yes. All right, anything, Ms. Malfino, other than that? All right, then, Mr. Guillory, at this time, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, but I'm going to follow the agreement that you made with the district attorney, defer all proceedings, place you on probation for 3 years. You're ordered to pay a $500 fine. You're also ordered to pay restitution in the amount of $4,600 and to follow all of the other rules and conditions of probation. If you do that, this is a great opportunity. You don't have a felony conviction on your record. And at the end of the probation, if you successfully complete it, you'll never be a convicted felon. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty, so you would be a convicted felon, and you could go to the state jail prison for between 6 months and up to 2 years. Do you understand? Yes. $4,600 is a lot of money to pay back. And a lot of people will think when they have restitution, I've got 3 years to do it. I'm going to wait, I'm going to sell something, or I'll wait till I get my tax refund or something like that. I want you to make payments on that every single month. Even if it's a little bit, it'll add up. Because what can happen is if you don't make payments on it, we can get to the end of your probation. You could have done everything else right. And if I find that you could have paid that restitution and you didn't, then you could still go to prison and be convicted, even though you've done everything else right but pay that money. It's very important that that gets paid back. And if you'll just make sure, I want at least half of that, anything he pays going to that. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. If you'll just have a seat here in the courtroom, probation will call you up to her desk when she's ready to go to your paperwork. All right, so that's you, sir. Thank you.
Thank you.
You've got Michael Thomas, Mr. Lewis.
Yes.
Good morning, sir. You're Michael Thomas Jr.
Yes,
And this is 23 DCCR 0530. Mr. Thomas is set for trial with jury selection Monday. And what is the announcement?
Reggie.
Okay, good. All right. So Mr. Thomas, has there been any change in any kind of negotiations or anything like that? So it's very likely that your case is going to be at the top of the list. It's obviously very old, need to get it taken care of. Stay in touch with Mr. Lewis. He will know that trial order tomorrow, right after lunch probably. But I anticipate seeing you next Monday at 1 o'clock. Okay. All right. See you then. And then you have a Charles Toussaint, Mr. Lewis.
Yes, right there. He's outside of the wheelchair jail.
Okay, go get him.
Yep. The nurse who to sit for the and put it up. I made it for that.
Good morning. You're Charles Toussaint,
Yes, ma'am.
and this is cause number 26 DCCR 0527. And what is the announcement?
Judge, there's some additional medical records I'm waiting on. I was able to, well, Mr. Toussaint, I was able to talk to the nurse this morning. They're compiling that together, the rest of it that I need. So hopefully I may have it today.
Okay.
But I can just have one more setting so I can review.
All right. Any issue, Mr. Smith? So Mr. Toussaint, I'm just going to do a normal reset. That's about 30 days to give you some time to get everything you need to Mr. Lewis so he can get it to Mr. Smith. They can talk about it and then you guys can visit, see what your options are, and we'll get that figured out at the next court date. All right. You're free to go. Thank you.
Okie dokie, friends. One more in Jefferson County. Let's march across the hallway to Judge Stevens, and we'll probably finish our day there.
All right. We now call cause number 26 CR 909, the state of Texas versus Clinton Thomas Edmondson. That's you, sir? Are you Mr. Edmondson? You have to speak up so she can hear. She's the court reporter. Good. Thank you. I'm sorry.
My mother's name got covered over for old age. I was in jail before. They gave me a name like this for the hospital.
But you are Clinton Thomas Edmondson. And you are charged in this cause number 26 CR 908. Here's the indictment here. With the second-degree felony of assault on a peace officer. And this states that on or about March 5th, 2026, this year, over here, on or about March 5th, which would have been April, May, June, July, August, 5 months ago, in Jefferson County, Texas, this states that you intentionally, knowingly, and recklessly caused bodily injury to the complainant, a police officer. Don't interrupt me. By striking the police officer in the face with your hands. And that you knew that he was a peace officer lawfully discharging an official duty.
I don't remember hitting no police officer. This
states that the police officer responded to the report of a person with a white hat and tan pants, and that was described as you, breaking the window of a pickup truck while trying to assault the person with a metal pole. This happened on Magnolia Avenue. The police arrived, saw you, and called for you to stop as you were walking away. You were holding a fence post and you dropped the post and stopped. When the police began to pat you down for weapons and safety, you struck the officer in the right side of his face with your hands. You punched him. It's in the debate. I'm speaking. Don't be rude. You get a chance to speak, but don't speak over the court, please. This isn't a debate and an argument, okay? All right. And there was a struggle, and then he had to activate his taser, and you were finally subdued and cuffed. The owner of the property at 350 Magnolia said he had told you to leave the property because you were trespassing. You became angry and threatened him with the fence post. So you are charged here with the second-degree felony of assault on a peace officer. If convicted, you are looking at no less than 2 nor more than 20 years in prison, and a fine up to $10,000 can be assessed. Oh, do you understand what you're charged with and the punishment range applicable here?
Do you understand what you're charged with?
Understand what you're charged with and what the punishment range is, up to 20 years in prison if convicted.
That's your question?
No, you're going to get a chance to speak in a minute. Just, do you understand what you're charged with? But I just read to you in English, and the punishment range of up to 20 years.
I don't know. I don't mean no harm, but I don't want to say the wrong thing because I know who I am. I know who I am. I got shot on the front premises. I got shot on the front premises way before.
We just need to know that you understand.
Nobody else, I don't know.
There's nothing about
I don't have
a
no
shooting.
friends walking the street. Someone was talking to me, and I don't know their conversation.
Okay.
But when it's
All right. So what we're going to do then
I don't know who's who.
is,
So,
do you know who
I mean,
you are?
hurt.
Do you know who you are?
Yeah.
What
but
is your name?
I went somewhere, but I'm hearing bad things. They told me, like I said, if I wasn't welcome to pay for noodles or soups.
Okay.
What's your name?
All
Clinton Thomas Evans.
Okay, that's right. You're right. You're charged with striking a police officer. That's why you are here, sir.
No, I don't.
Yes, it is while you're here. I'm not debating you.
Judge, I think he was just answering the allegation. It's just the allegation.
All right. What we're going to do is set this on a trial. We'll let a jury decide your fate, okay? And you're looking at up to 20 years in prison. And Mr. Turk, why don't you get with us if you need to file any other motions, if you know what I mean. That's what we're going to do until then. We're going to set it for trial. That is all.
Anywhere.
You supposed to be Lucy? Yes.
Next is Lucy Johnson.
Say anything, Lucy.
File a motion if you know what I mean. So in other words, he's headed off for a competency exam. Okie dokie, friends. That seems like a logical place to leave it for today. Thank you all for joining me. This was fun. A show that went off without a hitch, even though I wasn't sure it would go off without a hitch because on the pre-show we discovered I had an audio issue. So thank you again to those of you who are on the pre-show for helping me sort that real quick so we could put on a good show here. We'll be back in 2 hours time for second session right here on this channel, 2:30 p.m. Eastern, 11:30 a.m. Pacific. So do join me for that. That would make me happy, and I know you guys don't want me to be sad, so show up. Okie dokie, the wisdom for today. He that is good for making excuses is seldom good for anything else. That is courtesy of our friend Benjamin Franklin, and I'd have to agree with it. Okie dokie, friends. I will see you in a couple hours. Take care. God bless.